Any mention?
My lord, civil logistics intelligence, my lord. But the central bonded were matter that was listed on. Yesterday I mentioned, my lord, for listing it on instead of 4th on 6th, my lord. My lord, on the previous day, because of too much of heated debate, my argument, my lord, the interim order was not extended, my lord. And it was agreed that matter will be listed on 4th and now 6th, my lord. Now, in the meantime, what has happened, my lord? They are taking advantage of that the interim order has not been extended. So, my lord,
What have they done?
they are trying to issue an IT, my lord.
You have to put an application then, since it's not extended.
But the matter otherwise is coming on 6th only, my lord.
They shouldn't do anything. I don't think they should do anything.
They are doing, my lord. That's what my clients, they are interpreting it that way, my lord. That interim order has not been extended.
You have to put an application. Put it today only.
My lord.
Yes. Yes.
Hey, please, Lordship. This item number 24, my lord.
20?
24. On the last occasion, the last order, I was given an opportunity to file the rejoinder last day. Today, I will be filing today during the course of the day. This rejoinder, Lordship. This listed for hearing, Lordship. So
You're not filed it. We'll hear. We'll take a
we'll
other side.
I'll file it during the course of the day, Lordship. Today, I will file it.
You file it. If you file it, if it is on board by the time the matter is called out, very good. Otherwise, we will proceed the matter. Yes.
You know, only let it come next week.
No. Once there's an undertaking, you're filing it before the hearing.
The difficulty is because that
you file it. You see, you go to file it. Yes.
Lordship, back to mention item number 22, Lordship.
Yes.
Paying for respondent number 11. Some difficulty, Lordship. Can you allow us 3 weeks' time?
You for the petitioner.
I'm for respondent 8, 9, and 10.
Where's the petitioner? 22.
On behalf of the petitioner.
Yes. Is the same matter regarding cooperative bank? No. Which bank? Sir?
Yes. But 3
No,
weeks
not-
will be a longer time, Lord, because my
2 weeks.
petition
2 weeks, like on the prayer of
Respondent number 11.
Raven.
P. Hazarika.
Stands adjourned to after 2 weeks.
Yes, I'm P. Hazarika for respondent 8, 9, and
Hazarika is present. We have respondent number 8.
8, 9, and 10.
It will record it.
Obliged.
Similar prayer for item number 21, Lordship.
What is the problem?
Lordship, some difficulty for the conducting counsel,
You
Lordship.
don't want to pursue this matter.
We do, Lordship. Just 2 weeks' time may be given, Lordship.
Okay, 2 weeks. No objection.
Obliged.
Yes.
Lordship, I beg to mention item number 12, Lordship, of the hearing list, Lordship. I appear on behalf of the respondent number 4 to 8, Lordship.
Navin Chhetri,
Lordship.
you for the petitioner.
Yes, Your Lordship.
What's the matter about?
It's about selection process, my lord.
You have any objection?
Your Lordship.
Is new
No, Lordship. Shillong College, Lordship.
after?
3 weeks, Lordship.
Okay, 3 weeks. Yes.
Lordship, similar prayer for item number 19 and 20. They are connected matters, Lordship.
1920. Oh.
My lord, these are connected with 10, 11 also, my lord.
1920, 10, 11.
10, 11, my lord. These are contempt matters, my lord, connected with
12,
those.
1920 are connected to 12, we said.
No, Your Lordship, 10, 11 and 19 and 20 connected, Your Lordship.
Connected.
Why you want time those matters?
My lord, these are all connected matters, my lord.
So what? They connected, the better you hear them off. Yes.
My lord, these are for regularization of service. My lord, the one direction was given, my lord, that was not compliant. My
The
lord,
Paul's on the other side. Okay, yes, okay. Now say that.
yes.
10, 11.
And 19, 20, my lord.
Okay, yes.
Obligement.
Please, Your Lordships. Your Lordship, I beg to mention item number 15. Your Lordship, the conducting counsel, Mr. K.C. Gautam, is unwell.
Which matter?
15, Your Lordship. 15. 15, Your Lordship.
Setu Sangma.
Correct, Your Lordship.
But you've been conducting all the matters, so what's the problem?
No, Your Lordship. The hearing part, Your Lordship, Mr. K.C. Gautam is going to conduct.
So, Thaba, are you having any health problem? I hope not.
No.
Now, why not regular in court?
Sure, I'll try to be.
It's not done. You're young counsel. Your matters they've been fixed, and you
Yes,
feel especially and you not appear.
I'll make sure to appear, Lordship.
Yes, 2 weeks. Yes.
Oblige, Your Lordship.
Wait, please, Lordship. Lordship, I beg to mention this item number 14, Lordship. Lordship, I have taken the consent of the other side also, Lordship. I'm praying for 2 weeks' time, Lordship.
Who's appearing for the respondent? Mr. Sen.
Lordship, for any who, Lordship.
Okay, this after 2 weeks. Yes.
Give the oblige, Lordship.
Please, Lordship, I beg to mention item number 17. Pray for some time, Your Lordship, since we have not received any response.
Yes.
We have not received any response, Lordship. We have
Response from
taken. I'm for respondent born, Your Lordship.
Is a material respondent or is not necessary?
Yes, material, Your Lordship.
Otherwise, we'll have the matter. Is a matter regarding that.
Terminal benefits
Where's
and.
Mr. Devnan?
He's engaged in another court, Your Lordship.
We can't just adjourn it just like that. After 1 week, we will hear it is. Yes.
Lordship, I beg to mention item number 23, Lordship.
Lordship, I am appearing for respondent number 2 to 5, Lordship.
Why?
Lordship, in this matter, they are about to file their affidavit, Lordship.
What affidavit?
Rejoinder affidavit, my lord.
Rejoinder affidavit.
Rejoinder affidavit, my lord. We'll be
Why you
filing.
not filed it?
We'll be filing it.
You're
today.
for whom?
I'm for respondent number 2 to
Then
5.
rejoinder by you to what? Affidavit or rejoinder?
Rejoinder.
I have to file it. This too much. Taking time to become indiscriminate. Not. Okay. You ask Harpran?
No, Lordship. I'm Jad Begum.
Who's S Harpran?
She is my junior colleague.
Okay.
We'll be filing it today, Lordship, during the course of the
MSS
day.
Begum submits that the rejoinder to the documents, rejoinder affidavit to documents brought under court petition will be filed in the course of the day. According to the matter after 2 weeks. Yes.
Highly obliged, Lordship.
Are we hearing profile? Profile.
May it please the Lordship, I beg to make a mention of item number 16. I am appearing on behalf of Mr. S. Thapa, Lordship.
Mr. Thapa is here today.
No, Your Lordship.
Yes.
So basically, state is just a formal party in this case.
Yes. What's the matter about?
Business with regard to electricity connection, my lord, and the dispute and the property is not occupied by prejudice.
Yep, Mr. Thapa, no, after 1 week, yes.
Highly obliged.
Thirteen, 18. None. 24 are you? I have a job. Oh, 24, 50. Yes. Contempt orders on the main list.
Supplementary list item number 1.
May it please your lordship, I am online, my lord.
Yes.
Am I audible, my lord?
Yes, yes.
My lord, it's been a privilege to get an opportunity to argue before this rebel court. Now, my lord, the lead petitioner, my lord, happens to be a company registered in the Companies Act in Meghalaya. Now, the company, my lord, have a dealership of Toyota cars, my lord, in Meghalaya. They have a bank account in Meghalaya, my lord. Here, my lord, respondent number 2 all along communicated with the, my lord, the petitioner's company, and thereafter purchased 3 cars, my lord.
What's
Two
this
Innova
number 2?
and another car, my lord.
Yes.
And thereafter, invoice were made and everything were made. And thereafter, all of a sudden, my lord, respondent number 3 lodged an affair in Rajasthan, my lord, on the basis of which, my lord, my bank account in SBI, my lord, has been frozen to the extent of 20,25,000. My lord very well knows with regard to freezing of account. My lord, my local counsel, Mr. Mike, is there, my lord. K. Gurung is also there, my lord. Wherein, my lord, to freeze a bank account, my lord, notice has to be given to the person concerned whose bank account has been frozen. Even local magistrate has to be informed.
Where's the
And,
impugn? Where's the impugn order?
my lord, I have
The order of freezing.
Yes, my lord, the order freezing, my lord, is been communicated to us verbally, my lord. At page 54, my lord, will kindly come to page 54. That is a letter we have written to the state bank, my lord. They have received it. Again, my lord, at page 62, we have filed two representations with regard to that. Please communicate with regard to the order of freezing 20,25,000 in my account. They have not communicated to us. So at this stage, my lord, may I pray a reasonable prayer, my lord? Because this company is a business account, my lord. 20,25,000 is a huge amount, my lord. I am ready to give an undertaking to the respondent number 4 by signing my lord, bond that whenever it is necessary, I will provide it. Please allow me to use
Operate
that
account.
20,25,000, my lord.
No, I mean, are you allowed to operate your account except for 20,25,000?
Yes, my lord. I am been operating the account, but 20,25,000 has been freezed, my lord. That I cannot. And this has been done in violation of the express provision of law provided under the old Act, my lord, 102, and the new Act is 106, my lord. Absolutely, my lord. There is a judgment. Local counsel is there, my lord. May I ask him, with regard to the same subject matter, writ petition number 2180 of 2021, my lord. Herein, my lord, our High Court, Guwahati High Court, my
Now
lord.
you went and approached this. You went to this court of where is this? What is this? Page 60.
In Rajasthan Kota, my lord.
This is what is this?
In Rajasthan Kota, my lord.
Now what order is this? 17/10/2024.
That has been, my lord, that particular FIR that has been lodged by the informant, he was nowhere in the picture. He lodged an FIR on the very basis, my lord, my bank account has been frozen to the extent of 20,25,000. He filed a petition in Kota, my lord, asking for the Jimma of 20,25,000, and the court rejected it, my lord. And I am before the constitutional court, before this honorable court, wherein this honorable court, relying on Supreme Court judgment 2018 as well as 2019, my lord, wherein the mandatory provision is not being followed, my lord, that order is being set aside. At this stage, may I pray for issuing of a notice, my lord, and a reasonable, my lord, interim order to that extent that I will submit a bond to the State Bank of India and giving a bond of 20,25,000 whenever necessary, I will produce it, my lord. That is paragraph 19, my lord, will kindly come to paragraph 19 of the particular judgment, my lord. Honorable Justice Devasis Borua's judgment, my lord, I argued in this matter, my lord, before Honorable High Court. And these are mandatory provisions, my lord, and as such the court has interfered with it, my lord. Because this has not been complied with. Paragraph 19, my lord. And here also bank account, my lord.
Do one thing, Mr. Bhuya.
Bhuya, yes.
You should notice who's having a State Bank. Because there's no respondent today. This is Standing Council.
By registered post, my lord.
The State Bank, they have a council, local council, I think.
Okay.
Because the other one is your respondent number 1 is this what Ramganj Mandi police station. This is in Rajasthan. Yes. And these two people are also in Rajasthan. So to effect fast notice will be difficult. We'll do one thing. We will just serve notice on State Bank. Let them appear. Today is Wednesday. On Friday, then we will consider interim orders. Yes. Heard Mr. A.K. Bhuya, learned counsel for the petitioner, issue notice to all the respondents by tomorrow. The matter concerns the freezing of the account for an amount of rupees 20,25,000.
Yes.
Of the petitioner, which is a car dealership, correct?
Yes.
Which is a car dealership stop. Been submitted that the freezing of the said amount has been without due process, and that the action of the where's the order of freezing? You said you don't have it.
OC, my lord.
The order of freezing which has been passed by the respondent number 1 is therefore without any jurisdiction. Stop. As the respondent is not represented today, let dusty notice be served at least on the respondent number 4, State Bank. This is the matter day after tomorrow for consideration.
May I pray for on 3rd, my lord?
3rd for interim orders, yes.
3rd on my...
For consideration of interim prayers.
Yes, deeply obliged for that.
Daily list, item number 1.
Yes, Chanda.
Lordship, this is connected to the item number 2, Lordship. Item number 2 is the main matter, Lordship. Lordship, in item number 2, Lordship.
Item number 2.
Lordship, here we have challenged the subsequent order issued by the respondent number 3, Lordship, where they have revoked all.
Order meaning you file a contempt first against.
We had filed the contempt.
Earlier they filed a writ petition.
Writ petition, my lord. This is the second round of litigation, Lordship. What had happened is, by the order dated, Lordship, 31/7/24, Lordship, I was reinstated in the post of headmaster, Lordship. Thereafter, the managing committee had preferred an appeal, Lordship, not admitted, and against that order, Lordship, they had issued, respondent number 3 had issued one order revoking all orders, Lordship. Now, against that, Lordship.
That is not given effect, my lord. In fact, on the last occasion also before this honorable court, my lord, we had made this submission, my lord, and this honorable court, my lord, decided to keep this contempt pending for the time being, my lord.
Okay, yes, what about their service on other response, item number 2? An affidavit, have it been filed?
Lordship, we are still awaiting, Lordship.
Has it been filed on 1, 2, 5 and 7?
Only respondent
1, 2, 5 and 7.
In item number 2, when we come for respondent number 7.
You file affidavit. 1 to 5 no, haven't filed also. You file in 2 weeks, we'll take up the matter.
Respondent number 6, Lordship, have not yet entered appearance, Lordship.
We are still,
Lordship, we are still awaiting from the postal department, Lordship.
Sorry, not heard. Mr. Kibar Haji, learn G and Bihar response 1 to 5, and T. Dakhar, learn counsel for response number 7. Pray for not further 2 weeks time to file the respective affidavit stuff. It is noted that though the respondent number 6 has been served, no appearance has been made on his behalf. Just on also for further orders, yes.
Item number 3.
My lord, on behalf of the state respondents, my lord, Island is the counsel. I'm praying for further time, my lord.
Why?
My lord, she is on bereavement, my lord. Today is the funeral.
This is filed since 24.
Yes, my lord. This matter is my lord, this will be the 3rd time, my lord.
He's serving. The petitioner is serving.
Yes, your
Yes, as prayed for the 2 weeks times allowed for affidavit. Yes.
Item number 4.
Your Lordship, in this case, I'm appearing for respondent number 3, Lordship.
Yes.
In fact, this petition can be disposed of, Your Lordship, if Your Lordship be kind enough to come to the prayer of the petitioner, Your Lordship. They'll be at page 9, Your Lordship.
You're appearing for counsel?
No, respondent number 3, Lordship.
Who's one number 3?
Headman, Your Lordship. Darbar.
What's the matter about?
Lordship, this is regarding the appointment of election of the this headman, Lordship, because this current headman has been serving for quite a long time, and then there has been no darbar.
That is not the case, Your Lordship. If Your Lordship be kind enough to come to the prayer, Your Lordship.
Yes.
The simple prayer of the petitioner is to direct the respondent to convene a village darbar, Your Lordship.
Yes.
Yes, Lordship.
So, Your Lordship, we are willing to convene in darbar, Your Lordship.
You are for the Darbar?
Yes, Your Lordship.
When? Within
3 months' time, Your Lordship.
Within 3 months?
Maybe 2 months, Your Lordship.
By allowing all the adult members to participate.
That will be as per the custom, Your Lordship.
As per the
custom, Your Lordship.
Isn't Harim's imship?
Yes, Your Lordship.
Do you need a supervision of the officer of this imship? Not necessary.
Not necessary, Your Lordship.
Not necessary.
Let that be on record. That's not necessary, Lordship. If the valid says so, then that is
Not necessary, Lordship.
Yes, the grievance of the writ petitioner is with regard to the non-convening of a darbar. Because you are aggrieved with his actions.
Lordship.
With regard to allow the village residents to air their grievances. And of Urukso, Pabatha village under Rajshabang, Karim's imship, for non-convening of the bar to allow the village residents to discuss village affairs. Stop. It has been submitted by Mr. Tidakar that despite multiple reminders, the respondent number 3 has not responded to the request of the residents. And in fact, even a complaint has been filed before the council. Which respondent? For respondents 1 and 2. Stop. Mr. Majao, who is present on behalf of number 3, submits that if this is the only grievance, the respondent number 3, that is the headman. Why is you have made by only you are the current headman now?
Yes, Your Lordship. Only by name, not by office, Your Lordship.
Yes. Anyway, respondent number 3, who's headman of Sawapatha, is ready to convene the darbar within 2 months and to allow the residents to bring up whatever village affairs they may deem necessary. It's further submitted that in this darbar, it will not be necessary for any observer or supervision to be done by the officer respondent number 4. Next paragraph. On hearing the council parties, we've seen that this matter can be disposed of at this stage itself on the concession made by respondent number 3. So accordingly, it is directed that the respondent number 3 shall convene the village darbar of Sunsun village within a period of 2 months to give this order by allowing all village residents, bona fide village residents, to participate and take.
Some observation, Your Lordship, that the petitioner should not interfere, Your Lordship.
Petitioner interfere in
Should
what
not
way?
interfere because before filing the petition, we try to convene Darbar, Your Lordship.
Lordship,
But the petitioner interfere, Your Lordship.
how they are convening, Lordship?
Fully cooperate with the darbar in this regard. Matters transclosed in the suppose of this.
Hurry up, Your Lordship.
item number 5.
Please, Your Lordship. Lordship, we have filed. We have taken fresh steps, Your Lordship, with regard to respond.
Number?
3 to 8, Your Lordship.
3 to 8.
Officer indicates that notice is not complete. The ED cards not received. With regards 1, 3, and 8. What about the other respondent 1 and 2? Have been filed.
My lord, I require some time.
Mr. Marpan, being
Respondent 9. I will need some time.
you file affidavit?
Not yet.
Yes. I thought no, first indicated also. Let's stop Mr. Arguru. Next paragraph. On behalf of number 1 and 2, S. Marpan on 9. Also pray that they be allowed further 2 weeks time to file affidavits. On this matter of 2 weeks for affidavit for service report on the respondents 3 to 8. Yeah.
Item number 6.
We have taken steps on all the respondents, my lord. Last occasions, respondent number 6 was
not been represented. Against that also we have taken steps.
1 second.
Your Lordship, I'm appearing on behalf of Mr. S. Arlington, counsel for respondent number 5, and we would like to seek some more time.
Who's number 6?
Your Lordship, will be filing my power today, Your Lordship.
Okay, that's complete.
One and 124?
124 state.
What instructions you have?
If you filing affidavit, just need some clarifications also due to the elections. There was a delay.
All the respondents are represented today. MS Mr. Khan for 124. What's your name?
Your name.
Your name?
CL Mauplang.
MSCR Moklang Vice SLing for 5. Then you are
Respondent 6, IS Your Lordship.
yes, I serve for respondent number 6 who has just entered appearance, and Mr. LCM for 7 and 8. They all pray for to be further to stand file affidavit. Prayer aloud. Madam.
Obliged.
7.
Please, Your Lordship, this is matter of Sadarship of Nongpo. I'm Sadarship Nongpo.
Nongpo Sadarship.
Nongpo Sadarship. I'm required to file. I'm for respondent number 1 to 4. I'm required to file that inquiry report.
The first inquiry report.
First inquiry report, and also the list of the electors. Exact list of electors.
What's the matter? How is it situated now?
Lordship, this matter pertains to the suspension of the Sirdar of Nongpo Sadarship. Initially, he was suspended, then he was reinstated. Now he's been suspended twice, Your Lordship. Now, Your Lordship, during the course of hearing, on the same set of allegations. So, Your Lordship was of the observation that the inquiry report of the first inquiry proceedings should be placed before Your Lordship to examine whether it's on the same allegations or not. So that for that they're taking time.
The problem is that because of the EC, there's no EC.
Marapan submits that due to the transition that's about to take place in the office of respondent 1 and 2. Some more time will be required for necessary instructions or materials.
We list after 3 weeks, actually, because the swearing-in ceremony is also going to happen.
Brief. According to this matter for 3 weeks, yes. It will be recorded. Yes.
Lordship, and the interim order will continue.
Interim order, if any, can continue next.
Item number 8.
This is the Weybridge case, Your Lordship. So the similar matter has been, my Lord, restored by my Lordship, that Commissioner and Secretary, whether he is the competent authority. That issue has come up.
That matter, the matter has already been filed before the Honorable Supreme Court. That matter is pending.
But there is no stay, my Lord. If there is no stay, how they can say the matter is pending? Cannot be.
We have just received the instruction, my Lord. We'll file our affidavit.
No, Lordship, only thing, my Lord, my sense of urgency, my Lord. Otherwise, the license.
Out of the Weybridge, how many? 1 year, 2 years?
My Lord, it is due to expire, my Lord. The license is due to expire in May.
The
Lordship, at least take a call, my Lord. Lordship, take a call, my Lord, whether it is covered or not, my Lord. Nothing else.
Let them file affidavit.
Yes.
My Lord, only my prayer will be, Your Lordship. Let it be, my Lord. He will file an affidavit. Let him file an affidavit within a week, Your Lordship.
No, my
let
Lord,
it come up for.
reasonable time has to be given.
No, but Lordship has granted already 3 weeks time.
Further 2 weeks time, file affidavit.
Lordship can only pass, my Lord. Matter will be taken up after that, Your Lordship.
Matter will be taken up.
This was Your Lordship. No, this Lordship has expressed this, and the next date it will be decided.
No, the thing is that you see, Mr. Sen, now the other factors come into play. That okay, file SLB. That's besides the point. Let them file an affidavit whether the order of DB covers.
Exactly, my Lord. That is if it is not covered, Lordship will dismiss it.
You've been out of the Weybridge how long? 1 year, 2 years?
Yes, my Lord. After 1 year.
So 3 years you waited?
No, not 3 years, my Lord. So a few months, Your Lordship. No, those decisions I will sign, my Lord. If it is a covered case, my Lord, it cannot be denied.
See, who's saying we're denying you?
No, my Lord.
We say give them a fair chance. Let it be a level playing field.
But only thing, my Lord. It's the only thing be taken up, Your Lordship.
I know. Yes.
9.
You're appearing 9 and 10.
Appearing for respondent number 10. Lordship.
What about 9?
We have served, we have taken steps, Your Lordship.
Yes?
We have taken steps.
9 ED card, but 10, Miss.
I am.
9 is whom?
9 is the village. Or CM, Your Lordship, CM of.
CM of whom? Right, Mobu. What's the matter about?
CM Right Mobu. Acquisition of land, Your Lordship.
Acquisition of land and the construction of the.
Mr. PD is under the parents today on behalf of number 10. However, office note indicates that service respondent number 9 is still not yet complete. What to do?
We will.
The petitioner to obtain status of service on respondent number 9 by the next date. Yes. You want to file affidavit?
Yes, Lord.
What about?
My lord, I have not been given a copy of the.
I will give.
Why do you give a copy?
I'll give to your lordship.
How do you expect your case to proceed then? You
Beg
won't
your
give a
pardon,
copy.
your lordship.
6 to 8.
6 to 8. MSR Colony for 6 to 8 submits that. You got copy?
Yes, your lordship. That should be fine, yeah.
Yes. Take down this. MSK Guru 123 submits a FLB file within 3 weeks. Sub MS Colony, however, for 6 to 8 submitted that she is yet to be served a copy, but she is directed to serve a copy. Just a matter after 3 weeks for affidavits. What about 2, 4, and 5? After 3 weeks. Yes.
Obliged.
Supplementary list, item number 2.
May it please, just before my learned friend begins, only 30 seconds. Earlier I couldn't get the authorities. I got the 3 authorities on the point that unlike court or tribunal, a statutory body is not vested with the inherent powers. So I'm giving those judgment to my esteemed colleague. He may also go through it. Because earlier, I didn't press this point because I couldn't lay my hand on the authorities. I got the 3. 52 Supreme Court, please have it. He may look into it. Para 15. And then, Lordship also may. And then, my Lord, there are 2 division bench of 2 different high courts, Madras and Bombay. For court?
Yes.
Yes, please. And then is Bombay. Yes. Bombay. Bombay. 2 division bench, 1 Supreme Court. So, my lord, that point also now I will press. Both inherent lack of jurisdiction as well as
earlier.
My lord, it's not a 100-meter race.
That the commission.
It is not a 100-meter race because I could not lay my hand on the authority. Without authority, my lord.
Now, my lord, this is a new point.
Your points now,
my lord, it's not a 100-meter race. My lord is doing justice before us. So, my lord, if the law comes to our notice, we can always place it. So, my esteemed colleague can deal both with the inherent lack of jurisdiction as well as acting beyond the jurisdiction.
My lord, and they have given up the entire case on inherent lack of jurisdiction. They said that, and it was, and this should have been fair when they said that the commission has the power, inherent power to do it. They are not questioning the power. They are questioning the.
What about those 2 appeal judgments, which are
3. I now have got 1 more, my lord.
We have got 2. They have got 3. But the difference is we have got 3-member.
I will deal
3-member bench order.
I will deal with that.
They have got 2-member bench order.
That is not a judgment. That is not a judgment.
Even if that's not, I'll argue on that also.
That is not a judgment.
That means we will be arguing till the sun goes down.
It's not. But I will press both inherent lack of jurisdiction and acting beyond the jurisdiction. Both the facets.
Because now, my lord, when I submitted, that is not case. It is not a case of inherent lack of jurisdiction, because their entire argument is that it is a wrongful exercise of jurisdiction. In case of wrongful exercise of jurisdiction, my lord, my submission was that they should have gone to the alternative efficacious remedy. They should have gone to the appeal, because the parameters your lordship has already seen that it has to be violation of principle of natural justice. 1. Second is that it's a wholly without jurisdiction and completely absurd. These are the 3 parameters which this court and the Honorable Supreme Court has laid down for invoking the jurisdiction of this code under Article 226, my lord. These are the 3 parameters, my lord. I have relied on, my lord, on this. There are 2 compilations.
So, this is a 51 second before,
yes, my lord.
Before we come to. That means you're talking about implied powers and express powers in regard to inherent jurisdiction.
Statutory body, because commission is a statutory body. It is neither a court nor a tribunal. It has trappings of a tribunal. This was the argument. But I will argue on both. I will argue on
This is a new
both.
argument which has come today.
My lord, I
but
will
I will
succeed.
deal with that also.
I will
my lord.
succeed even on the second point.
But are you sure these are still in vogue?
My lord, 1952 Supreme Court, I also made a search. It has not been deviated from. Yes. It has not been overruled, 52 Supreme Court. And there are two division benches of the High Courts, Madras and Bombay.
We have the power of review also under the Act. The Commission has the power of review also under the Act. And Commission has the inherent power also when there is a procedural violation, my lord. And that aspect has been dealt by the Commission. I will take your lordship to that aspect, my lord. It's not a case of inherent lack of jurisdiction, my lord, because the judgments which have been cited now, my lord, I surely are not on those provisions of law. But first, my lord, first and foremost, I take my argument from the stage where I left, my lord. The argument which I made, my lord, is in reference to Electricity Act of Article Section 11111, my lord. Kindly see Section 111 of the Electricity Act.
Yes. Appeal to tribunal.
Yes, my lord. The Electricity Act confers power on and the section is, my lord, 111.
Yeah.
110, your lordship may kindly see first. The central government shall by notification establish an appellate tribunal to be known as Appellate Tribunal for Electricity to hear appeals against the orders of adjudicating officer or the appropriate commission under this law or any other law for time being enforced. The tribunal has been established, my lord. Now 111. Any person aggrieved by an order made by an adjudicating officer under this act, except under section 127, or an order made by an appropriate commission under this act, may prefer an appeal to the appellate tribunal for electricity. So, by or an order made by the appropriate commission. So, the provision of appeal under section 111 is available to the petitioner, my lord. He could have gone and he has a right to file an appeal against the order of the Meghalaya State Electricity Commission, my lord, MSERC, my lord. Now, when this kind of power is there, my lord, and I am covered by your lordship's last time I cited, my lord, for the judgment, my lord, 3 orders passed by this honorable court in volume 1, if your lordship kindly see. Is there is a compilation. There is a compilation like this.
Have you filed affidavit here in Pioneer Carbide only?
We have filed affidavit in Pioneer Carbide.
Okay.
We have filed the affidavit in Pioneer and BIA also, my lord.
Yeah, so which page is this?
I'm referring to, my lord, compilation.
Yes.
Kindly see page 24, my lord. The decision of this honorable court on this issue, my lord. And then your lordship will kindly see the parameters which have been laid down by this by division bench of this honorable court, my lord.
Yes.
Kindly have paragraph 2 also, my lord. There is no dispute that order impugned is amenable to an appeal under section 111 of the Electricity Act.
Yes.
There is also no dispute in my humble submission that this order of the commission is amenable to appeal under section 111 of Electricity Act, my lord. Now 4, my lord. Ordinarily, when an efficacious alternative remedy is available, the writ court exercises a degree of self-restraint before entertaining a petition under 226 of the Constitution of India filed without availing regulatory statutory remedy. The exceptional situation in which the alternative remedy is disregarded and the writ petition is received may be when the order is found to be in breach of principle of natural justice, wholly without jurisdiction, or absurd to the meanest mind. So the parameters which have been laid down by this honorable court, my lord, is clear, my lord, and in my humble submission, my lord, none of the parameters are satisfied by the petitioner, my lord. And this order, my lord, has attained finality because SLP against this was dismissed as withdrawn, my lord. So this order of this honorable court, my lord, has attained finality.
Yes.
Your lordship has also taken a view in somewhat different factual setting that the alternative remedy has to be exercised, my lord. That is the page 28, my lord.
Yes.
At page 28, and the line is, my lord, paragraph 7 at page 33. So this, your lordship has also relegated the parties to the alternative remedies in this. Though
Para 7.
Para 7, your lordship, selling the if not a temporary disconnection, if your lordship will see page 29.
Yes.
State condition in so and so, State Electricity Committee pointed out.
Yes.
So this view has already been taken, my lord. Third judgment, my lord, is at page 34. But before I take your lordship to third judgment, my lord, there are two recent judgments which are there with me, my lord. I have prepared one.
Second compilation.
Second compilation, only relevant paragraphs judgment, my lord, because question of law is raised, so then I have to answer this. Yes. Now, my lord, in this volume 2, my lord, serial number 1, my lord. All these authorities are on the issue, my lord, of alternative efficacious remedy, my lord.
That you're
referring to serial number 1, my lord.
PHER.
PHER, my lord. Yes, my lord. PHER. A matter, my lord. Kindly come to paragraph 22, my lord, of PHER.
Para 22.
Yes, my lord. Now, in para 22, my lord, the principle has been discussed in thread manner, my lord. The scope and the manner in which, my lord, the writ remedy can be availed, my lord. Kindly see.
Yes.
This is arising out of DRT matter, my lord. The law with regard to entertaining a writ petition under Article 226 of the Constitution in the case of availability of alternative remedy is well settled. In Satyavati Tandon, this court observed thus: unfortunately, the High Court overlooked the settled law that High Court will ordinarily not entertain a petition under 226 of the Constitution if an effective remedy is available to the aggrieved person, and this rule applies with greater rigor in matters involving recovery of taxes, my lord. Kindly mark cess, fee, or any other type of public money. Here also, my lord, public money is involved, and the dues of banks and other financial. In our view, while dealing with these petitions involving challenge to action taken for recovery of public dues, High Court must keep in mind that legislations enacted by Parliament and state legislatures for recovery of such dues are a code unto themselves, inasmuch as they not only contain a comprehensive procedure for recovery of dues, but also envisage constitution of quasi-judicial bodies for redressal of grievance of any aggrieved person. Therefore, in all such cases, High Court must insist that before availing remedy under Article 226 of the Constitution of India, a person must exhaust the remedies available under the relevant statute. While expressing the aforesaid view, we are of the consensus that power is power under Article 226 of the Constitution to issue any person or authority, including appropriate case, government direction, order, including writs, my lord. The then 23, my lord. It could thus be seen that court has clearly held that High Court will orderly not entertain a petition under Article 226 of the Constitution if an effective remedy is available to the aggrieved person. It has been held that this rule applies with great rigor in matters involving recovery of taxes, cess, fees, or other type of public money and dues of banks and financial institutions. The court clearly observed, while dealing with the petitions involving challenge to action taken for recovery of public dues, etc., High Court must keep in mind that legislations enacted by Parliament and state legislatures for recovery of such dues are a code unto themselves, inasmuch as they not only contain the comprehensive procedure for recovery of the dues, but also envisages constitution of quasi-judicial bodies for redressal of grievances of an aggrieved person. It has been held, though the power of High Court under 226 of Constitution are widest amplitude, still courts cannot be oblivious of the rules of self-imposed restraint evolved by this court. The court further held that though rule of exhaustion of alternative remedy is rule of discretion and not only of compulsion, still it is difficult to fathom any reason why High Court should entertain a petition filed under Article 226. Lord,
yes.
The series of authorities are quoted here, my lord, in the subsequent paragraphs. So, my lord, the law on this is well settled, including paragraph 20. This ultimately paragraph 28, my lord, where the Honorable Supreme Court says, my lord, it could thus be seen that this court has strongly deprecated the practices of entertaining writ petition in such matter. My lord, Electricity Act also, my lord, is a complete self-contained code. It has got the remedy, it has got the entire process of challenging the orders passed by the commission, my lord. And when it involves the recovery of public money, my lord, your lordship ordinarily, I am not saying your lordship can't, your lordship has the power to entertain when those tests are met, my lord. So in this judgment, my lord, is squarely applies to my case, my lord, and the next judgment, my lord, on is on electricity matter only, my lord. Jaipur in this compilation, Jaipur Vidyut Vitran Nigam Limited versus MP Power Limited, my lord, and paragraph 128 of that judgment, my lord.
One 128.
128.
In Rajkumar Sivar. No.
When this is the judgment Jaipur Vidyut Vitran Nigam Limited versus MP Power, my lord, and it will be the paragraph will be at page.
Page in
Running page, my lord. Running
560.
Yes, my lord. Running page will be 60.
60.
60.
Yes.
60. We find that High Court was not justified in entertaining the petitions. The Constitution Bench of this court in PTC has held that Electricity Act is an exhaustive code on all matters concerning electricity. Under the Electricity Act, all issues dealing with electricity have to be considered by the authorities constituted under this Act. As held by the Constitution Bench of this court, the State Electricity Commission and the learned APTEL have ample power to adjudicate in matters with regard to electricity. Not only that, the tribunals are tribunals consisting of experts having vast experience in the field of electricity. As such, we find that High Court erred in directly entertaining the writ petition when respondent, that is writ petitioner before the High Court, had adequate alternate remedy of approaching the State Electricity Commission. This court in Reliance versus so-and-so held that while exercising power judicial, this court can step in where manifest unreasonableness or arbitrariness is made out. In the present case, there is not even allegation with regard to effect. In that effect, in such circumstances, recourse to petition under 226 of Constitution in India, efficacious remedy under a statute which is a complete code in itself, in our view, was not justified. So, view was not justified, and then, my lord, the other judgments are also discussed, but these two paragraphs I will not burden this honorable court with other judgments, my lord. Just kindly take note of one judgment also in the first compilation, my lord, that is South Indian Bank versus Naveen Matthew Philip, my lord, at page 34. And the paragraph in this case is, my lord, paragraph 16 onwards, my lord, reiterating the same point which I have.
I think you placed it last time, I think.
Yes, my lord.
Paragraph 16, 17, 18.
Yes, my lord. So this, so my submission, my lord, is that the petitioner has the effective alternative remedy. This court has taken a view, my lord. The Honorable Supreme Court has taken a view, and therefore, my lord, in my humble submission, this petition is fit to be dismissed on this ground alone, my lord. Now, coming to back to, my lord, submissions. with regard to before commission of the commission.
One second.
Yes, my lord.
Yes.
Before I take that point, my lord, I must say with all humility, my lord, that this petition itself is not maintainable because it is nothing but an abuse of law, my lord, abuse of process of law. Why do I say so, my lord? That petitioner did not disclose, my lord, that petitioner has already approached this honorable court through its association BIA Industries, my lord.
They are part of that.
They are part of this the association, my lord.
Yes.
So therefore, and they are part of this association, my lord, because this part they should have stated, my lord, they have filed, the BIA has filed one rejoinder in the Honorable Supreme Court, my lord. Sorry, in the APTEL, in one of the matters, and all the parties here before individually are part of BIA, my lord. Kindly see, my lord, the declaration made by BIA.
This is Pioneer Carbide.
Pioneer Carbide, Sham Century, all these are, my lord, and kindly see the last page, my lord. Last page of the second number, your lordship will find Pioneer Carbide Private Limited, Siam Sanctuaries, all of them are party, my lord.
1 and 2.
1 and 2, and in fact all other petitioners also, my lord.
Pioneer Carbide.
Siam Century, if you lordship will kindly see 24, my lord. Siam Century Ferrous Limited.
Yes.
So through association they challenge only recall order, my lord. Your lordship, through association they challenge only recall order, and they do
one step further here in Pioneer.
and through association. So if you have given up, if you have given up,
yes,
you can't maintain second writ petition on the same cause of action, my lord, and this is unfair on their part.
Yes.
The unfair on the part of petitioners in not disclosing this fact to this honorable court, my lord. The writ remedy, my lord, is equitable remedy. An equitable remedy, you are approaching the courts with unclean hands, with suppressing the material facts.
Yes.
Lord, this is a very serious matter, my lord. On this ground alone, it should be thrown out, because they have suppressed the fact that they are before your lordship under the BIA, under the umbrella of BIA, and now they are saying that. And also, my lord, you say that the commission has power, and
BIA is the umbrella case.
Umbrella case, and they are challenging, my lord. What they are challenging is the recall order. They are not challenging the consequential judicial order passed by the commission, my lord. There is no challenge to that.
Have they mentioned in petition that they already joined in another proceeding?
No. They have concealed this fact. Concealment of this fact. I have gone through. I didn't. They have concealment of fact, and even assuming for this, they can't maintain in their individual capacity also, my lord. It amounts to abandonment, my lord. I will place those judgments, Sarguja Transport and all.
Sarguja Transport, 1977.
Yes, my lord. That is but the principles are, my lord, very clear, and they should now, my lord. I have already shown that the case is fit to be dismissed on the ground of alternative remedy, my lord. Now kindly see the nature of the power exercise, because that 3 judges bench, full bench judgment, and all those issues have been, which I said it is nothing but red herring, my lord. Kindly see the Electricity Act for a moment, my lord. What are the powers in the Electricity Act? Because those ultimately, when we are dealing with the provisions of Electricity Act, first provision, my lord, kindly see section 62, or my lord, section 61 to 64, my lord. This is the chapter under chapter 7, my lord.
Yes.
The
From 61.
61 tariff regulations, my lord. The appropriate commission shall, subject to the provisions of this act, specify the terms and conditions of determination of tariff, and in doing so shall be guided by following, namely principles, methodology, my lord. These are principles we are not concerned with, my lord. So the commission will specify the terms and conditions and determination of tariff, and doing so guided by principles which are A to H, my lord, A to I, my lord. Now section 62. The appropriate commission shall determine the tariff in accordance with provisions of this act for supply of electricity by generating company to distribution licensee, provided that appropriate commission may, in case of shortage of supply of electricity, fix the minimum or maximum ceiling of tariff for sale or purchase of electricity in pursuance of an agreement entered into by a generating company and licensee or between licensee for a period not exceeding 1 year, or to ensure reasonable price of electricity, transmission of electricity, wheeling of electricity, retail sale of electricity, provided that in case distribution of electricity in the same area by 2 or more distribution licensee may, for promoting competition among the distribution licensee, fix only maximum ceiling price for electricity. The appropriate commission may, by 2 my lord, require a licensee or generating company to furnish a separate details as may be specified in respect of generation, transmission and distribution for determination of tariff. 3 my lord, appropriate commission shall not, while determining the tariff under this act, show undue preference to any consumer of electricity, but may differentiate according to the consumer's load factor, power factor, voltage, total consumption of electricity during any specified period or more at a time which a supply is required, or geographical position of any area, nature of supply and purpose of which the supply is required. No tariff or part of tariff may ordinarily be amended more frequently than once in any financial year, except with respect to any changes expressly permitted under the terms on fuel surcharge, etc. my lord. Now 5. The commission may require licensee or generating company to comply with the procedure as may calculating the expected revenue from tariff and charge which are permitted to recover. 6 my lord, if licensee or generating company recovers a price or charge exceeding the tariff determined under the section, the excess amount shall be recovered by the person who has paid such price and charge along with interest equivalent to this, my lord. Then, my lord, 63, determination of tariff for a bidding process, my lord. Your lordship has taken note, my lord, that kindly take one aspect also in mind, my lord, that there is no challenge to the tariff order on merit. The tariff order which is before your lordship, there is no challenge, there is no whisper that tariff order has been in violation of 61 or 62. They have not questioned the tariff order on merit, my lord. Now procedure for tariff order, my lord, which is this is requires is a kind of quasi-judicial hearing. An application for determination of tariff under section 62 shall be made by generating company or licensee in such manner and accompanied by such fees as may be determined by regulations, my lord. Kindly mark regulations. Every applicant shall publish the application in such abridged form and manner as may be specified by the appropriate commission. 3. Appropriate commission shall, within 120 days from receipt of application under subsection 1 and after considering all suggestions and objections received from the public, issue tariff order accepting the application with such modification or such condition as may be specified in that order. Reject the application for reasons to be recorded in writing if such application is not in accordance with provisions of Act and the rules and regulations met thereunder or provisions of any other law for time, provided that applicant shall be given reasonable opportunity of being heard before rejecting the application. The shall within 7 days making order send a copy of the order to appropriate government authority and the concerned licensee and to person concerned, notwithstanding anything the tariff interest etc. my lord not relevant. 6 my lord, a tariff order shall, unless amended or revoked, continue to be forced for such period as may be specified in the tariff order. So what I say, two things based on 64, my lord. One, that it is in the nature of quasi-judicial proceedings, my lord, where the regions to be, there is a requirement to record the regions, my lord, by the commission. the requirement to give reasonable opportunity of hearing also, my lord. All these are having trappings of hearing in the quasi-judicial capacity. This is one aspect of the matter, my lord. And linked to this aspect is, my lord, when the matter is heard by two persons, two members, including chairman, in a judicial proceeding, my lord, whether order can be passed by one member.
Yes.
And all along, the commission, APTEL, has been saying when matter is heard by 5 and decision has been passed by 4, matter has to be heard afresh. 3 orders will, my lord, when but last one is, my lord, tariff order shall, unless amended or revoked, continue to be in force for such period as, so the amended or revoked. This in itself, my lord, contains power, my lord, of the commission to even amend it, because revoke it, amended or revoked, my lord, revoked.
Yes.
Now, my lord, kindly see 86. The functions of State Commission. The State Commission shall discharge the following functions. Determine the tariff for generation, my lord. The procedure your lordship has seen in section 64. State Commission shall discharge the following functions, namely, determine the tariff for generation, supply, transmission and wheeling of electricity, bulk, etc. My lord, these are the functions. Now, F is adjudicate upon disputes between licensee and generating company and to refer any dispute for arbitration. So the dispute is also, my lord, that can be adjudicated by, it's not by consumer, my lord.
Yes.
BIA is, my lord, consumer. Then, my lord,
this is between licensees and generating companies. It's not to do with consumers.
Yes, my lord. So, my lord, they are the consumers here, my lord. They are not here. If your lordship will kindly see, adjudicate dispute between licensee and generating companies and to refer any.
Licensee will be distribution companies, you mean?
Distribution companies, because they are the
generating companies different.
Different, my lord. Your lordship has taken a view in that matter also. That there is an order on that also. But we are concerned with the aspect, my lord, of matter heard by 2, decided by 1, my lord.
Yes, that's the crux of the matter.
That is one also aspect, my lord.
Yes.
This 86, my lord, 86.3, your lordship may kindly see. State Commission shall ensure transparency while exercising its power and discharge its function. Transparency involves, my lord, that the one who hears decide. Is not one who hears with in a combination of 2 and he will alone decide. Because there is a vacancy. That aspect also I will see, my lord. I'll deal with that aspect also. So it will be completely anathema to the judicial propriety, because this is a judicial hearing, quasi-judicial hearing before commission or of the commission, my lord. These are, in my humble submission, completely irrelevant considerations. Because requirement is that one who hears decide does not mean one who hears as a part of combination of the members and then he will take a call individually. Kindly envisage a situation where the second member has not retired, my lord, and one member passed the tariff order. Then it will become a tariff order because he has heard and without quorum, and therefore there is no requirement of quorum. Quorum principle will not apply. He has passed the tariff order and thereafter, that order cannot be recalled in exercise of inherent power. Because the other member can also pass the tariff order, my lord, because he has heard, he has not retired.
Okay, that's just anyway, hypothesis. Yes.
That's a very strange proposition of law, my lord, that which I'm sorry. So, your lordship, kindly see. And then there is a certain, why? Because this tariff order has got far-reaching implications, my lord. The Honorable Supreme Court has always said that you have the hearing of these tariff orders where at least 2 members or judicial members' presence is required. I will point, but most important thing, my lord, commission cannot exercise all these powers without the authority of chairperson also. That is also required, my lord. Kindly see section 92 in this regard.
So it's threefold, you mean?
Yes, my lord. The without chairperson commission is not in existence. Section 92, your lordship, kindly see. And admittedly, there was no chairman when the order was passed, my lord. Proceeding of the appropriate commission, my lord.
Where does it say that?
Yes, your lordship will see. I will 92 kindly.
Yes, 92.
Yeah, appropriate commission shall meet at the head or office at such places as the chairperson may direct.
Yes.
And shall observe such rules of procedure in regard to transaction of business in its meeting, including quorum at its meeting as it may specify, my lord. So quorum is also required, and meeting can be convened by chairperson. The chairperson of is to, my lord, if he is unable to attend a meeting of appropriate, any other nominated by chairperson. In this behalf, and absence of such nomination where there is no chairperson, any member chosen by members present among themselves, my lord, always plural, shall preside the meeting. All questions which come up for any meeting of the appropriate shall be decided by majority of votes of the members present and voting, and in the event of equality of votes, the chairperson in his absence, the person presiding have a second or casting vote.
So a chairperson has to be there.
And then, my lord, 5 also, my lord. All orders and decisions of the appropriate commission shall be authenticated by secretary or any other officer of the commission duly authorized by chairperson in this behalf. So in absence of chairperson, those orders are nullity. And proceed 95, my lord, 95, which was highlighted, my lord.
Yes.
All proceedings before appropriate commission shall be deemed to be judicial proceeding within the meaning of 193 to 20 of these are judicial.
What about 93?
95, my lord. Proceedings.
What about 93 then? Vacancies?
93, my lord, vacancy. I'm sorry, that part. Vacancy not invalid. Now, no act or proceeding. Now, your lordship, kindly envisage a situation when matter has been heard by 2 members. It is not a case of vacancy. For example, there has to be 3 members of the commission, and the decision has been passed by 2 members, my lord. 1 chairperson and 1 the other member.
So you mean to say that if there is not constituted properly,
yes,
suppose there's some
yes,
vacancy,
yes,
so the proceedings are carried out and signed by the members present,
yes,
with the chairperson's authorization,
yes, my lord,
is valid. That's just absence of a member. Are you trying to say that will not, vitiate the, will not disable the proceedings?
No, my lord, it's a situation where when the commission, as on today, commission is having 2 members, my lord, or 3 members, for example, 3 members. Now the matter has been heard by chairperson and member, and 3rd members retire. So those, because there is a distinction.
So if 1 third member retires, if a chairperson is there, that means that is a valid proceeding.
The chairperson is, hearing has to be by, if hearing.
So this 93 can't be drawn
in quasi judicial hearings, my lord. Kindly, 93 cannot be drawn into those hearings which are judicial in nature, my lord.
Invalidated proceedings will mean what?
Proceedings, my lord, that is also rightly put by your lordship. Proceedings mean what? Those quasi-judicial proceedings or proceedings under 86, where there are some administrative orders, etc. are passed, my lord. It's not a vacancy, because this provision cannot be invoked to sustain the matter heard by 2 and decided by 1.
No, we'll come to that. But
yes,
the thing is that whether, no act proceeding of the appropriate commission shall be questioned,
yes,
or shall be invalidated merely on the ground of existence of any
vacancy or defect in the constitution of appropriate. Defect will be, my lord, if your lordship will kindly see that the requirement of members, my lord, and that your lordship will find shall be majority, my lord. Kindly see 92 once again, my lord.
Yes.
Or first, your lordship, see kindly 86, because 86 deals with
Functions.
function, and then the constitution of the membership, that is, your lordship will find 82, constitution of the state commission.
No, just to clear the doubt.
Yes, I bow down, my lord. That issue is that
You have
also.
to clear- you have to be,
Yes,
you
yes,
be clear about
yes,
what you know.
yes, what is the import of that 93?
Of 93.
Yes, my lord. Kindly see 82, constitution of state commission.
Yes.
Every state government shall, within 6 months from the appointed date, by notification, constitute the purpose of the act a commission for state to be known as Electricity Regulatory Commission. And kindly see 82(4).
Yes.
A state commission shall consist of not more than 3 members, including chairperson. So, if there is a vacancy, my lord, and the hearing is conducted by 2 only, including chairperson.
Okay.
So then, that under 93, my lord, that plea is that the orders passed by chairperson and member, whereas the requirement is that you should have at least 3 members, will not invalidate the orders passed by the commission. That is the import and purpose of section 93, to save those orders where commission is not fully constituted.
Okay.
Not to save those orders where matter has been heard by 2 and 1 person retires, and therefore that would not amount to hearing in law, my lord. That would not amount to hearing under section 64, my lord. Because section 62, if your lordship will kindly see, it says that the determination will be subject to the act. The tariff is, kindly see, it is subject to provisions of 61 itself says, appropriate shall subject to provisions of this act. So all the act says, my lord, the requirement is chairperson, requirement of.
So just want
Yes, my lord.
to be clear.
Yes, my
what will constitute a valid commission?
Yes, my lord.
So
Valid
whether,
commission will be.
Valid commission. Suppose you said not more than 3 members, so we can see in one the proceeding will not be invalidated.
Yes,
if chairperson is there.
Yes, my lord.
Now in this case, what we're trying to understand is
Yes,
that
my lord.
in this case it was heard by 2 members.
Yes, my
the
lord.
chairperson and a member.
Yes,
a member law whatever.
Yes, my lord.
And the order was not generated at that time.
Yes, my lord.
It was subsequently heard, but part by 1 member.
Yes.
How valid is it?
Because that
and whether 93 will
3 will
save whether 93 will save this
No,
action. of the
in my
commission.
humble submission, 93
That's the only
is
thing.
93 will not save those orders which are heard in judicial capacity. It will save those orders where commission is not fully constituted and only their requirement of 3, only 2 members are there, 2 chairperson, and they are hearing the matters. Then saying that it is a violation of 84(4), as there are 3 members are required. State commission should consist of 3 members. Only 1 is consisting or 2 are consisting right now. Therefore,
Okay.
that is now, my lord.
I go to the next point, that is
Yes, my lord.
96. You said.
Yes,
Oh,
my
no.
lord. Now one more provision, my lord. 121.
Now 95 is important then.
Yes, my sorry. I'm sorry. I'm jumped.
So no, proceedings. Definitely
Yes, my lord.
proceedings.
Judicial proceeding. Now proceedings before the commission, my lord.
That's your point.
Yes, my lord. This is my all proceeding before appropriate commission shall be deemed to be judicial proceeding within the meaning of 193 and 228 of the Indian Penal Code, and the appropriate commission shall be deemed to have civil code for the purpose of section so and so and so of criminal proceeding. So, if the proceedings are, my lord, judicial proceedings, I do not fathom, my lord, that in judicial proceeding matter can be heard by 2 and decided, and decision can be rendered by 1. And that is why APTEL order after order has been setting aside those orders. And the straw or the help which being taken, my lord, that section 121, that order of 2001, my lord, passed by the
You mean the power of appellate tribunal?
a power of appellate tribunal. My lord, kindly see this is not. There are 2 powers, my lord. Under section 111, my lord, of hearing the appeal, and second, direction to pass the direction by the appellate tribunal. These orders are at best, my lord, are administrative orders. These are not the orders, my lord, which can be termed a judicial order, because judicial orders will come under section 111, my lord. And I will place one judgment of the Honorable Supreme Court, recent judgment, my lord, which says that the decisions of the appellate tribunal, appellate authority, is binding on the state commission, my lord.
Okay. It should be binding.
It should be binding, my lord. I need not cite the judgment for that proposition, my lord. That the decision of the judgment is binding. Now, kindly see the language or expression used in section 121. The appellate tribunal may, after hearing the appropriate commission or interested party, if any, from time to time issue such orders, instructions or directions as it may deem fit to any appropriate commission for the performance of its statutory function under this Act. And this appellate tribunal itself, my lord, I will place that order of which is impugned. Under 121, direction has been issued by the appellate tribunal to follow the regulations, because those regulations are statutory regulations. Those regulations cannot be violated by the commission.
Okay. Yes.
And your lordship has seen in 92 subsection 5 that the order has to be authenticated under the
authority
of the chairperson, my lord. And the regulations are also saying in this regard, my lord, one or two provisions of the and then I am done with the Electricity Act, my lord, section 145, because there are in other cases there are some interim relief, etc. also sought, my lord. No civil court shall have jurisdiction to entertain any suit or proceeding in respect of matter which is assessing offence, or an appellate authority under or the adjudicating officer appointed under this Act is empowered under this Act, or no injunction shall be granted by any court or other authority in respect of action taken or pursuance of power conferred under this Act. So this is the purpose of showing 145 is that it is self-contained code, my lord, and 174 is, my lord, 174 is that acts to have overriding effect. Why I am showing all these provisions, my lord, that it is a self-contained code, mechanism has been provided, the tribunals have been constituted, appellate forum has been conferred with the power to test the orders of the authorities and commission under the Act, my lord. Act to have overriding effect, save as otherwise provided in 73, as provisions of this Act shall have notwithstanding anything contained therewith, any other law for time being, any instrument have other than this Act. So, my lord, and then rule making power, my lord, 180. And the state government may by notification make rules for carrying out the provisions of the Act. And then 181 regulations, my lord. They can make out these regulations, my lord. Power of the state government to make regulations. State commissions, my lord.
Yes.
Before your lordship, I have already submitted on the last date of hearing that there is no challenge to the provisions of regulation. Yes. And the requirement laid down in those regulations, my lord, are crystal clear. And kindly see the regulations, my lord, in this regard, my lord.
Page 129.
Yes, my lord. Page 129, and the regulations are 9, 10, 18, 21 and 26. Page 1, my lord. In exercise of power conferred by section 181 2 ZL read with 92(1) of Electricity Act and all powers enabling it in that behalf, the Meghalaya Electricity Regulatory Commission hereby makes the following regulations, same having been previously published in the official gazette in so and so, my lord. Now, the provision, my lord, 9.
Conduct a meeting.
8, my lord. Proceedings of the Commission. All hearing, examination, inquiries or consultation held or conducted in meetings shall be deemed to be proceedings of the Commission. A matter shall be heard or considered by Commission in a meeting. Commission, while hearing and considering it, may, if consider it necessary, to do so, co-opt officer of any person possessing knowledge, required experience, present, take part in meeting, but such person shall not have the right to vote, because assistance I can seek from technical members. And 4, my lord, all proceeding before commission shall be deemed to be judicial proceeding, because that is already there. That is line with the statutory provisions which is there in 595. So then the provisions are there, my lord. Now conduct of the chairperson shall preside over the meetings of the commission. All questions in meetings shall be decided in majority of the votes of the members, and in equality votes, the chairperson in his absence, persons presiding shall have second casting vote, my lord. Quorum. Where the commission has also one member or more, the quorum for a meeting shall be 2, including the chairperson. And your lordship has already held that quorum. This issue fell for your lordship's consideration, my lord.
In which case?
In case, my lord, which is in the first.
So many LC cases. Even I myself lost track.
So
orders
if this the matter fell for your lordship's consideration, my lord, and that order your lordship has passed. If your lordship will see, the compilation is there, because I also so many, my lord. Page 28 of the first. I will just page 28.
Yes, the same you placed it.
Yes, my lord. No, there is one. There is one more, my lord.
Quorum. This is not the quorum.
Your lordship has said, taken note of my argument, and based on that, your lordship has held that the quorum is 1 and the person is 1 only. That is there, my lord. I'm sorry, I'll place that, my lord. I have that order with me, where your lordship has taken note. In fact, it is part of my counter affidavit. Just show me the counter affidavit. If your lordship will see the counter affidavit in this matter, and page 44, my lord. Sorry.
Marbanya project 171.
Yes, sorry, 39, my lord. 39.
No, just see 171. This is one.
Yes, 39.
One no. In this first compilation, 171.
171, my lord. They have, yes, 171.
From an index.
Yes, my lord. 171 only. It's a huge index. 171, my lord. In the index only. Yes, my lord. If your lordship will kindly see, these petitions have been filed against the order of learned chairperson of Meghalaya on the ground that orders are without jurisdiction and suffers from procedural infirmity, as the issue concerns the grievance of individual and are not disputes between licensee and generating company, in which the commissions would have had jurisdiction to adjudicate. On behalf of petitioner, apart from jurisdiction, impugn order, the regulatory commission was competent to take up the matter non-extant law as they pass without prescribed quorum. Attention of this court with regard to jurisdiction and quorum has been drawn to the judgment of the Supreme Court and provisions of the Regulations Act, my lord. Mr. Paul fairly concedes, my lord, and then your lordship, on submissions of learned counsel parties, these petitions are disposed of without contest, however, with the following observations, my lord. Your lordship take note of the section 86 F, my lord. And then at 174 bottom, my lord, the state regulatory commission with regard to quorum has at section 10 provides as follows: quorum where the commission has also one member or more, quorum shall be 2, including the chairperson. In fact, the represents. So your lordship has already upheld the quorum. They can't come and say, and this order has attained finality, my lord. This order is binding, my lord, on them, my lord. So kindly see the requirement of the regulations, my lord. 10 I have.
Yes.
Quorum of the commission has one member or more. So then your lordship has already taken note of the quorum, and then your lordship will see the hearing, initiation, service, everything. 18.
Yes. Okay, yes. Yes, please continue.
Yes, page 6, my lord. On completion of hearing of or consideration of matter, the commission shall give its decision with reason thereof and shall pass orders including orders with regard to cost. The commission may also pass interim orders as may be necessary in time. All orders of the commission shall be signed and dated by chairperson and members, my lord. 92.5, my lord, chairperson and hearing and shall not be altered and except to corrected in apparent error. So if the regulation requires, my lord, that all orders shall be signed and dated by chairperson and members hearing the matter and shall not be altered except in where has the state commission gone wrong in holding that the order was non-est and it has the inherent power to do that. In any proceeding, the decision taken by majority shall be decision of the commission, and in case of dissent, the dissenting member shall give views separately. If the submission of the petitioner is accepted.
21, then a review.
Yes, my lord. Now, 21 is review decision by order. A person aggrieved by decision or order of the commission for which no appeal preferred and is not allowed to prefer can seek review of the order, and if no new important facts which after the exercise of duty were not within the knowledge could be produced before him.
And inherent powers.
Yes, my lord.
Yes.
Inherent power is there. 60. Your lordship have seen that 64 subsection 5 of Electricity Act also. The tariff order unless revoked and modified, my lord.
Nothing in this regulation shall be construed as barring the commission.
Yes, my lord.
From exercise powers of which provision.
So these regulations are not.
So you mean to say inherent powers encompass everything?
Inherent, because if I have power to alter, amend and revoke tariff order under the Act, my lord, kindly see section 62.5, my lord. 64.5. And the regulations have been framed, my lord, under those statutory provisions, my lord.
Yes.
A tariff order shall, unless amended or revoked, continue to be enforced such power as may be in tariff order.
Yes.
Unless amended, so the power is there that it can be revoked, altered, amended. And in my case is that it was not a tariff order because it was not.
That means if the wording is unless amended or revoked.
Yes, my lord.
So you're stressing on that. It
Yes,
continues to be enforced.
If unless
that means the regulatory commission has the power to amend,
yes,
revoke the tariff order.
Yes, my lord. Because that is why otherwise these words would have been
any consideration.
Any consideration.
Doesn't matter whether it's a quorum or a question of wrong tariff being applied.
There could be n number of practical situations.
The power is inherent.
Inherent because in tariff order, my lord, tomorrow the prices. And if I omit these words, the purpose of these words are enabling the commissions, my lord, because they are dealing with the realities of life every day. There could be earthquake, there could be some mishap, or could be the prices may go down or may come up within a period of 1 year. And to say that no tariff, the commission has no power, it can't do anything because tariff order is binding for 1 year. That is why the legislature has envisaged and has taken into consideration this situation, and regulations are in line, and these regulations in my humble submissions are not in challenge.
Yes.
These regulations bind them, it bind me, it bind them also. So therefore, my lord, and then at the multi 10 to 23, my lord. Regulation on next page, my lord. 10, 15, 20 and 111.
Regulations.
Yes, my lord. That is the MYT regulations. Multi-year tariff regulations, my lord. And the relevant is 15.
Just give me 5 minutes.
Yes. So, my lord, I was on the issue of the regulations. I was placing the regulations before your lordship.
Yes.
Now, the regulations, my lord, first, the regulations of MYT regulations I was placing, my lord, which is at page
10.
10. Yes, my lord. So, in MYT regulation, my lord, the provision which is relevant is 8, 9. Where is that? 8. 4, not there. If your lordship will kindly see 19.
1 second.
$15, $20.
Yes.
15, my lord, your lordship, 15 is relevant. The proceedings to be held by the Commission for determination of tariff shall be in accordance with MSCRC Conduct of Business Regulation 2007 as amended time to time.
15.
15, my lord.
Yes.
So the MYT regulation also requires that the proceedings of Commission
Yes.
has to be in terms of conduct of business regulations, my lord. So of the Commission or before the Commission, my lord.
Yes. Yes.
The notwithstanding 15.2, notwithstanding anything contained in these regulations, Commission shall at time have the authority either suo motu basis on petition filed by the interested affected tariff including terms of thereof or any generating company or transmission. Even suo motu basis it can be done, my lord.
Yes.
And 15.4, my lord, notwithstanding through a transparent process of bidding. So this is the requirement to follow Commission, my lord, is inherent in MYT regulations also, my lord.
Yes.
And 19, hearing of the application, my lord. The manner and everything, my lord.
Yes.
So the nature of hearing, my lord, is quasi-judicial.
So what you want to show is that the entire thing self-contained.
Yes.
The Parent Act provides this rule-making powers, establishment of state regulatory commissions, with other powers, quasi-judicial. So everything self-contained. So nothing can go beyond that.
That is one aspect of the matter.
Yes.
And single member cannot pass the order.
Yes. Yeah, of course. That,
Yes.
Yes.
And for this purpose, my lord,
Yes.
I place the authorities, my lord, which is first authority is PTC India.
In the compilation?
Yes, in compilation, my lord.
Number 2 or
PTC
1?
India, my lord, is 117.
1.
Volume 2, my lord. Because earlier I prepared in BIA, then matter it was said no, we have to argue this. All right. So then there was some.
Doesn't matter, as long as we get to the bottom of it.
Yes, my lord. So if your lordship will see the judgment of PTC,
Yes.
and that judgment is a constitution bench judgment, page 117, and particularly paragraph 47, my lord, at page. Kindly see the questions first, my lord, at page as questions framed by the Constitution bench at serial number 2, paragraph 2, my lord, at page paragraph 2. PTC. Paragraph 2, my lord. This is the Constitution bench judgment, and at page 124.
Preliminary.
Yes, my lord. Questions of law. The crucial points that arise for determination are whether the appellate tribunal constituted under the Electricity Act 2003 has the jurisdiction under section 111 to examine the validity of Central Electricity Regulation Commission fixation of Regulation 2006 framed in exercise of power conferred under 178 of 2003 Act. So whether Commission can override the regulation, because I have shown, my lord, to your lordship that the multi-year tariff regulation 2014 has been framed by the state government, my lord.
Yes.
And under power conferred, those regulations are binding. Those regulations cannot be overturned, overlooked, or ignored by the commission, my lord, which requires hearing by quorum, and proceeding has to be in terms of that. Whether Parliament has conferred power of judicial review on appellate tribunal for electricity under 121 of the 2003 Act, 121, my lord, and whether capping of trading margin, my lord, kindly come to then paragraph 26, my lord, at page 145, 144. The tariff is not defined in 2003 Act. The term tariff includes within its ambit not only fixation of rate but also the rules and regulations relating to it. If one reads section 61 and 62 of the 2003 Act, it becomes clear that appropriate commission shall determine the actual tariff in accordance with provisions of the Act, including the terms and conditions which may be specified by the appropriate commission under section 61 of the Act. Under 2003 Act, if one reads section 62 with section 64, it becomes clear that tariff fixation, like price fixation, is legislative in character, and the same under Act is made applicable by section 111. The provisions, namely section 61, section 62 and 64, indicate dual nature of functions performed by regulatory commission with decision making and specifying the terms of tariff determination. So it's a decision making, and the terms are also, so this, my lord, and then kindly see 47.
46 or 47?
46, my lord, is, yes, my lord, page 150, my lord.
150.
Learned Counsel lastly submitted the power of judicial review cannot be located in section 120 of the Act. The power under section 121 is different from power under 11. According to Learned Counsel, 120 powers of tribunal is act only when commission is guilty of inaction in carrying out the statutory functions. And a legislative act cannot be read into 121.
Okay,
yes, this is the principle, my lord. Now,
Yes,
47. On the above submission, one of the questions which arises for determination whether trading margin fixation under so and so, particularly when power regulation is correlatable functions ascribed, my lord, and the 50, my lord, this is the important paragraph which I am placing reliance at page 151, my lord.
Yes.
Applying to the above test, the price fixation exercise is really legislative in character unless by terms of particular statute it is unless by the terms of the particular it is made quasi-judicial in case of tariff fixation under section 62. My lord, why I am emphasizing quasi-judicial, because those one who hears must decide. It's not one who hears made applicable under 11 Act, and though section 61 is enabling provision, it only takes tariff as subject matter, so and so determination of fixation, my lord. The basic scheme equally applies to subject matter. So the constitutional bench, my lord, clearly has held that it is a quasi-judicial, and paragraph, how I distinguish, my lord, that the 121 orders, because 121 order has been relied by the learned senior counsel for the petitioner, my lord, and for that, my lord, kindly come to the summary of finding at 92, paragraph 92 at page 60, 163.
Yes.
In the hierarchy of regulatory powers and functions under the 2003 Act 178 deals with making or regulation by a central commission under the authority of subordinate is wider than one so and so enumerates regulatory functions and its per area to be discharged under. A regulation under 170 is a part of regulatory framework, intervene and even overrides existing contract between the regulated entities as much as it is a statutory obligation on the entities to align the existing and future contract with the said regulation. A regulation under section 120 is made under the authority of delegated legislation. Consequently, a validity can be tested only in judicial review before the court and not by way of appeal before appellate tribunal or extradition. So, my lord, the tribunals are, and four, my lord, most important, my lord. Section 121 of 2003 Act does not confer power of judicial review on the appellate tribunal, my lord. The words orders, instructions, and direction do not confer power of judicial review in the appellate tribunal for extradition. In this judgment, we do not wish to analyze the English authorities, my lord. So, the point which the full bench order of the 2001 order, my lord, which reliance has been placed, saying that before the commission, of the commission, if your lordship would recall,
Yes.
those are not the orders passed in judicial review, and the one of the limb of the submission was that this is an order passed by three full bench, and that order overrides the subsequent orders passed by the APTEL under section 111 of the Electricity Act, my lord. The Supreme Court makes it clear that these are this is 121 is not your judicial review order. And the law laid down in all these the orders by the commission is binding on them, my lord. And
so in this case, it was concerned with the whether this APTEL had the jurisdiction to determine the validity
of the regulation. And then for reaching, and the court held that no, APTEL has no power to do it. In reaching to that conclusion, the court also returned the finding that you cannot, under section 121, because you have power to issue certain directions, that is not a power of judicial review whereby you can review the legislation, those regulations. So in that context, my lord, this 121, the order the relied by are orders passed by the APTEL in exercise of 121. Those are not the judicial orders, my lord. If those are not judicial orders, they are not binding on State Commission, my lord.
Okay.
And those orders cannot, my lord, your lordship, the second submission which is flowing from that, those orders cannot override the regulations because the APTEL has no power to set aside or test the judicial review of the regulations, my lord. If the APTEL cannot examine the constitutionality or validity of the regulation, it cannot issue direction, my lord, to ignore those regulations, my lord. So from this constitution bench judgment, these paragraphs, my lord.
Just see the conclusion.
Yes, my lord.
So the appellate tribunal has to decide the validity of regulations framed by the So only by 226.
226, my lord. So whether the order of the APTEL under 121 can set aside the regulations framed by state government, which requires hearing by quorum, which requires hearing in the manner the adjudication process, my lord. In my humble submission, unequivocally no, my lord. It can't do it, and therefore that order has got no meaning.
Yes.
Now the other judgment, my lord, is in the compilation, my lord, is that Tamil Nadu Generation and Distribution Company, my lord. In Tamil Nadu Generation and Distribution Company judgment, my lord, if your lordship will kindly see paragraph 55.
Which compilation?
Is the same compilation in which PTC India, after PTC India, my lord. At page 166, my lord, judgment starts, and the relevant paragraph is, my lord, paragraph 55.
166.
$188, my lord. The object of showing this judgment, my lord, is
Yes.
that the commission, while determining the tariff, is exercising huge power, and it has to be more than one, and that is why regulation also provides for that, my lord, and that is what has been echoed by the Honorable Supreme Court in this judgment, paragraph 55. We, however, find substance in the submission of Mr. Nariman that adjudicatory functions generally ought not to be conducted by state commission in absence of judicial member, especially in relation to disputes which are not fairly relative to tariff fixation or advisory and recommendatory function of the state commission. And then, my lord, 59.
Yes.
In view of the aforesaid categorical statement of law, we would accept the submission of Mr. Nariman that tribunals such as State Commission, in deciding a list between the appellant and the respondent, discharge judicial functions and exercises judicial power to the state. It exercises judicial functions of far-reaching effect. Therefore, in our opinion, Mr. Nariman is correct in his submission that it must have essential trapping of the code. It can only be achieved by the presence of one or more judicial members in the State Commission, which is called upon to decide complicated contractual or civil issues, which would normally have been decided by civil court. Not only decisions of the State Commissions have far-reaching consequences, they are final and binding between the parties, subject to, of course, judicial review. What is being said, my lord, is that the commissions exercise, my lord, far-reaching power, my lord, and those powers should be in the presence of more than one member. In this case, my lord, Mr. Soni, member of the commission, is a legal member, but ultimately tariff determination is also a technical subject, my lord.
Yes.
And therefore, in absence of technical member, the commission should not have sitting singly, or one member should not have passed that order, because there was no technical member present. And the last judgment in this series is, my lord, Gridco, recent judgment, my lord, that is at serial number 7 at page 198, my lord, and the paragraphs are, my lord, 27 to 29. 26, my lordship may see
Paragraph
26, 27, 28, 31 at page
26, 27.
28 and 31 and page 217, my lord, of the compilation.
Yes.
The 26. The Commission exercises the power to fix tariff conferred by Section 62 of Electricity Act. We will have to note the nature of power exercised by Commission while fixing the tariff under Section 62 of the Electricity Act. A Constitution Bench Court dealt with the issue in PTC India, my lord. I have already placed that PTC judgment before your lordship, my lord. Now on next page, my lord, 520, my lord, just above paragraph 28. Thus, the function of the Commission of Tariff Fixation is a quasi-judicial function, my lord. And then, my lord,
yes,
the 28, my lord, last line. Thus, the members of commissions are experts in the field, my lord. 28, I will read, my lord. We may also note that dealing with the decision of bodies of expert like commission and appellate tribunal, appointment of members of commission is made by a committee of constituted and headed by judge, laid down in the qualification of post and member. It reads thus the members of commissions are expert in the field, my lord. And my lord, 29. So far as appellate tribunal is concerned, consists of chairperson and 3 other members provided. So the nature, the qualification, the expertise, my lord, they are highlighted, and kindly come to paragraph 31, my lord.
yes.
Thus, there is one more aspect of the matter as held by the Constitution Bench. Under Section 62, the Commission exercises quasi-judicial powers. These are appeals preferred by Commission against the order of the appellate tribunal in appeal under 111 of the Electricity Act. The appellate tribunal in appeals has dealt with the legality and validity of decisions of the commission rendered in exercise of quasi-judicial power. In short, the appellate tribunal has tested the correctness of the order of the commission. Commission is bound by the orders of appellate tribunal. Therefore, we have serious doubt about the propriety of legality of the act of commission in preferring appeal against the order of appellate tribunal. My lord, in that case, CRC challenged the order of appeal before Supreme Court. And then commission is bound by orders of appellate tribunal. So the state commission is bound by the decision of the appellate tribunal, and 3 decisions, my lord. On this point, my lord, I will take your lordship to 3 decisions, and including the recent one also, my lord. In 2024 also there is a decision which have been referred by, those decisions have been referred by Meghalaya State Regulatory Commission, my lord, and kindly note those decisions in the compilation number 1 at serial number 1.
So number 1?
So, yes, my lord, now kindly the volume 1, my lord. Volume 1, my lord, at serial number 13.
30?
13, my lord.
Damodar Valley.
Damodar Valley, my lord. Yes, my lord. Sorry.
Yes.
Now in Damodar Valley, my lord, if your lordship will see Union of India, the Damodar Valley, serial number 30. 13, my lord. Para, your lordship will see it's a short judgment, my lord. Paragraph 11. 178, my lord.
Further.
Yes, my lord. Damodar Valley, my lord. Paragraph 20, my lord. Whether the impugn order passed by first respondent Central Commission is sustainable. It is the specific case of the London Senior Council appearing for the appellate that outside the instant case has been heard by 4 members of the first respondent, the Central Commission, as early on 14/10/2014, and matter has been reserved for orders. It is admitted fact that order has been passed on 18 December 2017 only. It is admitted fact that the order has been passed on 18 December only and is not in dispute. Further, it is not in dispute that matter has been heard by 4 members of Central Commission. It is significant to note that out of 4 members, when 1 member has retired, is also not in dispute. It is manifest on the face of the cause title of the order. It emerges that only 3 members have signed the impugn order passed on 18 December, and the same was communicated to the appellant through the posting in the first respondent Central Commission website after a gap of 3 years and 2 months. It is astonishing to note that the said impugn order passed contrary to relevant regulations as per notification bearing number in office and the chairperson. It is noteworthy to extract the relevant clause 22, which reads under: the commission shall pass the order on the petition, and the chairperson and members of the commission who hear the matter and vote on the decision shall sign the order. Same in my regulation also, my lord. After careful reading of the regulation as stated supra, it is mandatory on the part of chairperson and members to hear the matter and vote on the decision shall sign the order, which is mandatory. And there is no saving clause as such to the fact that what is suffice to sign the impugn orders. Therefore, we are of the considered view there is a substance in the submissions made by learned counsel appearing for the appellant. We do not find substance for the respondent. As rightly pointed out learned counsel appellant in his rejoinder, learned counsel for this and so cannot be made applicable to facts of case. To substance, so my lord, the order was set aside on that ground. See, the second order, my lord, in this regard is, my lord, Jindal at paragraph serial number 8, my lord, paragraph 17, 18, 19.
One second.
Volume 2, Jindal is in volume 2, my lord. Sorry, Jindal is in volume 2 and
Page?
Jindal is, my lord, at page 234. And paragraphs are, my lord, 17, 18, 19. 243, my lord, is the relevant page.
Two 43.
Yeah, 243, paragraph 17, my lord. Jindal, my lord, 17. The argument that opinion of the third member in present case who retired before the order could be signed would not have material for all the regions, at all for the region that impugn order is signed by majority of the members of the commission who heard the matter is devoid of any force, my lord. It is for the region that even dissenting opinion by members shall have to form part of final order of commission in view of the above noted regulation of 22 and shall have to be available for inspection. Further, such an order cannot be treated to be outcome of joint deliberations of all the members of commission who heard the matter. It is often seen that members of the commission tribunal come to joint deliberations over a matter with their own view and they put forward before the other members, and sometimes even majority of the members having a contrary view get convinced with the reasoning put forward by the member in minority, and the minority view becomes the final order of the commission. In the instant case also, the third member of the commission, if consulted during the joint deliberations, had he been still in service at the time of preparation of order, he may have convinced the remaining two members who have signed the impugned order to take contrary view. This actually is the advantage of having joint deliberations between members of the commission at the time of preparing final orders of the commission. What section 92 subsection 3 provides is that decision of the majority of members who had heard the matter shall be final order of the commission, and in the event of equality of vote on the matter, chairperson in his absence of the member presiding shall have casting. It would be fallacious to say that legal provision is applicable to situation arising in instant case and would validate an order of the commission signed by only two members when matter was heard by three members. Such a view, in our opinion, would be against the basic principle of judicial decision making, making that those who hear must decide the matter. Section 92 shall have to be construed in a manner which would not render the regulation 21 of OERC regulations OTOs. It is a settled principle of law that regulations notified are binding on regulated entities till such time they are amended, set aside by appropriate forum. Therefore, instant case OEC regulations are binding on the State Commission also.
Okay.
And reference made to learned counsel correspondent to section 93/30 is absolutely misplaced. The section has already been produced in para 9 here and above. Bare perusal of the said legal provision would clearly reveal that vacancy and defect in the Constitutional Commission mentioned in the same relate to time when the matter was being heard by commission, that is at the time of constituting the bench to hear the matter. As per section 93, if there had been any vacancy in the commission at the time of hearing the matter, or there had been any other defect in the Constitutional Commission to hear the matter, same cannot be ground to question the order passed by such bench of the commission. Manifestly, this cannot be made applicable to a situation where there was no vacancy or defect in the Constitutional Commission at the time of hearing the matter, but vacancy arose subsequent to the completion of hearing of the matter. So, my lord, this also answers your lordship's query regarding applicability of 93, my lord. And then, my lord, latest judgment at page 247. Madhya Pradesh versus Central, 247. Again, my lord, so lordship has seen three orders.
Yes.
And relevant paragraph is 253, my lord.
Para 253.
Sorry, so page 253, paragraph 13, my lord.
So you conclude submissions now.
I'll finish it, my lord, in 10 minutes. I will try to expedite the process.
No, I'm not saying that's just that you do it.
Thus, the tribunal-wide order dated, your lordship will see this is 2024 order, my lord.
Yes.
And 13 we has held. This tribunal-wide order dated has held that here we find that impugned order of the commission is legally invalid. We clarify 24 and reiterate the legal principle that where one of the member of the commission who here demits the office by reasons of superannuation death before passing the, it is not permissible for remaining member of the commission to sign the order. In such a situation, matter shall be heard de novo and final order passed signed accordingly, my lord. So, my lord, these three orders take away.
So you're reading which page?
I'm sorry. I was reading the compilation, my lord, of the last page. Volume 253 of volume 2, my lord.
Yes. This is para 25.
Yes, my lord. Sorry.
Okay.
253, paragraph at the top, my lord. And bold, hence we find the impugned order of the commission unsustainable, legally invalid and non-est. Non-est, we clarify and reiterate that legal principle that where one of the member of the commission who hear a matter demits office by reason of superannuation, death, etc. before the passing of the final order, it is not permissible for remaining member or members of the commission to sign the order. In such a situation, the matter shall be heard de novo and final order be passed signed accordingly. That is what has happened in my case. It was heard de novo. Everybody was given opportunity.
Yes.
And appeal is hereby allowed. So the commission, my lord, Aptel's orders are binding on me, consistently binding on me, or binding on me. Now, my lord, kindly see the order, my lord, impugned order, because I have to take your lordship to the impugned order.
Which petition? BIA?
In Pioneer only, my lord. Now I have marked in Pioneer. Because in BIA there is no challenge to the tariff order, my lord. And my lord, I am not troubling your lordship because that will troubling with the order, the judgments of Supreme Court, my lord. Kindly just mark those in compilation only, my lord. That because those judgments have been referred by my learned senior, but those are part of compilation one only, my lord. I will just indicate the paragraph and judgment, my lord, so that volume 1. Lord, the judgments are, my lord, in the index only, your lordship, kindly see at the serial number 14, my lord.
This is the point of
orders passed without jurisdiction and nullity, my lord.
Yes.
That Pandurang versus State of Maharashtra, my lord. The citation and para is mentioned, my lord. Then Budhia Swine versus all relevant paragraphs are mentioned, my lord, because those judgments have been referred, they are not in dispute, my lord, that one who hears decide the matter. Their argument was that the learned member has heard the matter, therefore these judgments will not apply. It's not that they are contesting the point that one who hears should not decide. They are saying yes, one who hears, but he has heard the matter, therefore he is competent to decide the matter. Yeah. That is how these judgments are. Hearing means hearing by sitting together, hearing by members, my lord. Hearing is not hearing when the bench sits together, they hear the matter together, my lord. So yes. These are the 4 judgments, my lord. On that point, your lordship may take note because I am not repeating the same submission again and again, my lord. Now kindly see the impugned order now. The 105, my lord, page 105. page 106, my lord. Meghalaya Electricity Regulatory Commission referred to Commission after calling the objections and suggestions from stakeholders and issuing public notice in the newspaper, conducted the public hearing on 18th March 2024, 19th March 2024 and 20th March 2024. Matter was heard by the chairman and member law. However, due to the ongoing model code of conduct, the order matter could not be issued on 11th May. The chairman demitted the office due to superannuation. The order was finally issued on 5th June for true of so and so. Agreed by the order of the commission, the ME approached the Honorable High Court of Meghalaya by writ number so and so. Now, kindly see your lordship's order. Under chairman heard the matter. It was also pointed out Meghalaya State Electricity Commission regulation so and so provides for signing of all members who hears the matter. The Honorable High Court of Meghalaya, by the order dated 25th June, while issuing the notice to Commission, observed that prima facie matter deserves consideration and interim stay was granted on the impugned orders of the Commission on 5th June and 6th June until next date. Relevant extract of the interim order, Learned Senior Counsel has drawn attention to the court to the order of 5th June and 6th June, where he contends that have been passed in violation to Section 10 of Meghalaya Electricity Regulation Commission regulations, which prescribes that minimum core of the commission should be at least 2, including chairperson, and under Section 18.3, which specifically provides that all orders of the commission shall be signed and dated by the chairperson and members hearing the matter and shall not be altered except to correct the apparent error. It is further submitted that impugned orders herein has been passed by a sole member, 1 Sri R.K. Soni, Principal District Judge, so and so, sitting singly as chairperson, as retired on 12th May. On hearing, Learned Counsel for the parties, prima facie, it appears that matter deserves consideration at this stage. Interim order called for, then stay was granted. Now, next order, my lord, 16 July 2020. In that case, Honorable High Court of Meghalaya allows the commission is ready to re-examine the case. The utilities, meanwhile, prayed for withdrawal of the writ petition and permitted utilities to withdraw and re-agitate the matter afresh before the commission. The relevant extract of the order is produced below. Now, this is very important, significant, my lord. Learned Counsel for the petitioner prays that he may be allowed to withdraw the instant petition, as a statement has been made by the Learned Counsel for the respondent that matter will be taken up for reconsideration afresh by the Regulatory Commission. So, my submission is, my lord, that I withdrew the writ petition
on the undertaking.
On the undertaking.
Yes.
Otherwise, that order was nullity in the law, and I was entitled to come before your lordship under Article 20 in the parameters. It's because absurd. That order was absurd, my lord. Matter stands closed on withdrawal. The liberty to petitioner re-agitate the matter afresh before the respondent number 1. And BIA, my lord, BIA challenged the interim order before division bench. And it withdrew the writ appeal on the ground that the matter has been remanded back. So, my lord, this order has attained finality.
Yes.
That I have a right to be heard, my lord. This order attained finality.
Yes.
And then, my lord, the submissions. I will just briefly touch the submissions, my lord. Paragraph 11 of the submissions before the commission, my lord. The commission has passed the order in accordance with law. It is not even error within jurisdiction.
Para 11.
Para 11. Now, this is the submissions of the BIA, my lord. 10 is the introductory. Learned Senior Counsel further submitted commission post exercise of 62 and 64 of Electricity Act becomes functus officio, does not have any jurisdiction to re-hear and subject matter, has already exercised the decided it, and such application of is not maintainable. Then attention of the commission was drawn to regulation 26, my lord.
Where are you reading from?
I'm sorry, paragraph 11 at page 108, my lord.
The Counsel for Summary Conversions.
Functus officio. Plea was taken that once the tariff order is decided, the commission has become functus officio, my lord. Yes. Then regulation 26 of the MSCRC shall determine the tariff generating company. They draw the attention. And 13, my lord, paragraph 13 at 109, order passed is essentially an appealable order 1.1 of the Electricity Act, and there cannot be any recall of the same. That is the same plea which is being taken, my lord. I have shown the submissions, my lord. Now, kindly come to paragraph 20 at page 111. On a specific query of the commission pertaining to order and guidance of Honorable Aptel in appeal number 297 of Jindal Power, which I have shown, my lord, to your lordship, the Learned Senior Counsel submit that order of OP number 1 of 2011 dated 2/12/2013 was issued by larger bench comprising of 3 members, and directions were issued under 121 of Electricity Act in comparison to the order passed in 111, which is against the specific appeal. Direction contained in therein prevail over the guidance of the appel. So judicial orders will get set aside by order direction, and this also, my lord, this is also, now your lordship kindly see, even this order also will not come. The reliance has been placed, my lord, because I have to deal with this aspect. Kindly see B at 111.
Yes.
Of course, there were regulations framed by some other commissions meeting the quorum. These regulations also would refer to the quorum only for meeting of the commission, not for the proceedings before the commission. So, quorum, the commission has not taken a note of all those provisions, my lord. Quorum, signing of the order, one who hears the matter. These regulations provide the commission may hold such. The commission is dealing with quorum, but not the part of the order. The regulation which says that the one who hears pass the order, my lord. So therefore, even under 121, my lord, there is no direction. Now 21, my lord, learned senior counsel further that this is being essentially 21 under 120 of the Act would be binding on commission, cannot obviate, my lord. And the judicial discipline, same argument, my lord. Then kindly see our submission, 26, my lord.
Yes.
The Learned Counsel for the Meghalaya utility submitted that order issued by commission is without it is non-est void of an issue and suffers from manifest procedural impropriety, is violation of its own regulations submitted as per 18.3 of MSCRC Conduct of Business Regulations. All orders of the commission shall be signed by chairperson and members who heard the matter. Relevant regulation is quoted, my lord. 114 sub-regulation. All orders shall be signed and dated by chairperson and members hearing the matter.
Yes.
And shall not be altered except hearing the matter. It doesn't mean hearing singly. And 93 will come to rescue. In accordance with the above extract, the order on the particular matter have to be signed by chairman and member hearing the matter. How in current case demitted the office filed by utility of the matter should have been heard afresh and the order should have been passed. My lord, what is wrong with the order? I put a question to myself. This is the exercise of jurisdiction within, and if at all, my lord, they are agreed with this order, their appellate remedy is there. He further submit appel in Jindal, my lord, Jindal, which I have already placed before, my lord. Then all those judgments, my lord, are cited. 31, my lord, kindly see. Budhya Swain versus Gopinath. On the issue relating to jurisdiction of commission pertaining to recall its order, the Learned Counsel relied on the judgment of the Honorable Supreme Court in Budhya Swain, and kindly see small Roman 3, when the court itself commit a mistake which prejudices a party. Then A.R. Antule, my lord, is cited at the bottom of page 115, 116, my lord, at paragraph 8. Then, your lordship, the recent judgment of Supreme Court in paragraph 32 in Greater Noida Authority, my lord. In our paragraph, a tribunal, a court may recall an order earlier made by it if the proceedings culminated in order suffer from inherent lack of jurisdiction. Such lack of jurisdiction is patent. What patent illegality or patent lack of jurisdiction is there when member is not competent to? There exists a fraud and collusion mistake of the court. So there is an inherent power, my lord. And at page 117, my lord, paragraph 33, the Honorable Supreme Court's judgment in Shrey is cited, and at 118 bold portion, my lord, kindly see. In such a review, court or quasi-judicial authority having jurisdiction to adjudicate proceeding to do so, but doing so commit a procedural illegality which goes to the root of the matter and proceeding, and consequently order pass certain cases decision rendered by court without. So these are the powers which have been exercised, my lord, including at page 119, my lord, Pandurang judgment. Those judgments have been cited and everything. Now the issues have been framed by the commission, my lord, at page 122. Did the commission have jurisdiction while issuing order of 5th and 6th June regarding true up period so and so, my lord? And whether commission can recall the order issued as above and rehear the petitions, my lord? The commission refers to section 92, my lord. Then proceedings of the commissions, my lord, conduct of business, quorum, It takes into consideration all relevant material, my lord, and page 125, my lord, paragraph 48, it is bound by the decisions of the superior tribunal, that is Aptil, my lord. Damodar Valley judgment is taken into consideration, my lord. All the case laws taken into consideration, and after taking into consideration, my lord, it comes to the conclusion that that order is not binding, and it deals with, my lord, that order, my lord, paragraph 52 at 129, that Jindal, that the OP1 of 2011, which has been heavily relied by the London Senior Counsel, my lord. We would also like to refer the judgment dated 11th November 2011 of the Appellate Tribunal in OP1. The judgment was passed by the Appellate Tribunal on a suo motu petition taken by the Appellate Tribunal based on letter sent by Power Ministry complaining that most of the state distribution have failed to file annual tariff revision petition in time. As a result, in a number of states, tariff revision has not taken place for a number of years, and a state commission constituted all over India have also failed to make periodical tariff revision suo motu, resulting in poor financial health of the state distribution utilities. Due to this fact situation, the Power Ministry requested the tribunal to take appropriate action by issuing necessary direction to all the state commissions to revise the tariff periodically. If required by suo motu action, in the interest of improving the financial health, long-term viability of electricity sector in general and distribution utilities particularly, Appellate Tribunal has directed the State Electricity Commission follow their own regulations. Relevant paras are really. So in 121, the full bench is saying follow the order, my lord.
Follow the own regulations.
Follow the regulations and orders. We are in any case bound, my lord. Then, my lord, at 131,
yes,
whether commission can recall the orders issued as above and rehear the petition itself, my lord. And power to recall, my lord, inherent power, that was not argued because they have given up. Now they have argued, your lordship, kindly see. It is necessary to note the issue of power jurisdiction of the courts or tribunal to recall their orders is no more res integra. The law has been settled in canon of judgment passed by the Honorable Supreme Court. It is now settled that a court or tribunal is invested with ancillary or incidental power as may be necessary to discharge its function effectively for the purpose of doing justice between the parties, and in absence of a statutory prohibition in appropriate case it can recall its order in exercise of such ancillary or incidental power. In this regard, reliance is placed on Greater Noida Authority versus Pravijit Singh Soni. In the Greater Noida case, the issue before the Supreme Court was whether NCLT order whereby NCLT had refused to recall its order was correct. One of the issues framed in the Honorable Supreme Court was whether NCLT had the power to recall its order. Relevant paragraph. While deciding the issue holding that NCLT have power to recall its orders, Honorable Supreme Court had dealt with Rule 11 of National Company Law Tribunal, which is reproduced below. Nothing in these rules shall be deemed to limit or otherwise the effect inherent power of tribunal to make such orders as may be necessary for meeting the ends of justice or prevent the abuse of process of tribunal. After noting the various judgments passed on this issue, the Honorable Supreme Court concluded as follows. Law as emerges from the decisions above, that is, the tribunal or court is invested with such ancillary incidental power as may be necessary to discharge its function effectively for the purpose of doing justice between the parties, and in absence of statutory prohibition, in appropriate case it can recall its order in exercise of such ancillary or incidental power. In recent decision, my lord, I am then kindly come to paragraph 133. Page 133, paragraph 50. In the light of discussion above, what emerges is court or tribunal in absence of any provision to the contrary has inherent power to recall an order to secure the end of justice or prevent abuse of the process of court. Therefore, paragraph 59, my lord, emerges that Honorable Supreme Court upheld the power of NCLT to recall the order inter alia can be passed without jurisdiction. On a juxtaposition 60, finding of the Honorable Supreme Court with the present set of facts following crystallizes. Commission has inherent power under COB regulations where regulation 26 as follows. Nothing these regulations shall constitute as a bar commission for exercising act which provisions have not been made and have been made in order to serve the spirit of the act. Roman 14. In addition, it must also be noted tariff proceedings were undertaken in pursuance of multi-year regulation. Regulation 111 also grants inherent power to commission and is reproduced as below. Roman 15, my lord, in view of the COB regulation, it becomes evident that commission has inherent power akin to NCLT. In the present case, the earlier order passed by commission was without jurisdiction. Notably, there is no statutory bar in the COB regulation act which prohibits commission from recalling. Therefore, such circumstances order is recalled, my lord. 61. Yes, further power jurisdiction of the commission to recall its order can also be traced to inherent power of the court undertaken procedural review when order suffers from procedural illegality which goes to the root of the matter. Position has been in Shrey infrastructure, my lord. then the free infrastructure which referred to, my lord, and based on that, my lord,
The finding was rendered.
finding has been recorded. Now, the question which falls for your lordship's consideration is, my lord, that this is within the jurisdiction of the tribunal to pass, because what they are saying is that writ remedy is available to them is on the ground that the order passed by the tribunal is wholly without jurisdiction. That's
the only
that's the only point. Now I have shown, my lord, from the judgments of the Honorable Supreme Court, in the recent judgments, all those in electricity matters, this is the exhaustive provisions, and all those orders of APTEL are very clear, which says that when the matter is heard by 4 and 3 decides, it is non-est.
What about the other matter which was heard by this court and defeated decision bench with regard to that memorandum?
That those are pending, my lord. Those are
Pending was Supreme Court.
before the commission only. Those special tariff matters.
It's still pending.
Yes, it's still pending. I am told it's still pending.
But they'll have no impact on this.
Because that was for 22-20. That was for the previous tariff. Because every year we have got tariff.
No, it doesn't have any impact.
That doesn't have any impact.
On this
No, and this was, and then your lordship has also transferred those matters to the appropriate forum. That order is there here, my lord, because there is a there is a forum where consumer can.
Oh yes, consumer
can raise the dispute, my lord.
No, that has no.
This has got no bearing, because every
just in the back of my mind.
No,
a tariff because
no,
BIA
is now separately contesting it before the forum. That forum
that has no link.
That has no link. That has got absolutely no link. Absolutely no link. At no bearing at all, my lord. Nothing. No connection. Now kindly see, my lord, what the 3 judgments, my lord, of the compilation on the jurisdictional aspect, my lord, because they are saying that jurisdictional error, my lord. If your lordship will kindly see, the Justice Nariman's judgment, my lord, in Bhadra, my lord, that is at serial number 2 of the serial number 3 of the new compilation, my lord. Bhadra judgment, my lord, paragraph 67, 87. Sorry, paragraph page 67, paragraph 21. Now, in they are raising that the issue is that the commission was wholly without jurisdiction, my lord. They did not say so, my lord, in clear terms, but still I take their argument to that level, that their argument is that the commission had no power to review and revisit the order. That is what they are trying. Kindly see the page 67. And the paragraph is, my lord, 21. At page 81, my lord. Though this is a case in the context of, my lord, section 34, but the exposition of law is very relevant with regard to issue of jurisdiction, my lord. 21.
I accept this proposition.
That jurisdiction. So jurisdiction is a coat of many colors, and that the said word displays a certain coloring depending upon context in which it is mentioned. It is well said. Sorry, the jurisdiction is a coat of many colors, and that the said word displays a certain color depending upon the context in which it is mentioned. Is well said. In classic sense, official trustee versus Sachindranath Chatterjee, jurisdiction is stated to be in order of reference to a full bench. In Sukh Lal Sheikh versus Tarachand Ta, it was stated that jurisdiction may be defined to be power of court to hear and determine a cause, to adjudicate and exercise any judicial power in relation to it. In other words, by jurisdiction it is meant by the authority which a court has to decide matters that are litigated before it, or take cognizance of the matter presented in a formal way for its decision. An examination of the case in the books of disclosure numerous attempts to define term jurisdiction, which has been stated that the power to hear and determine the issues of law and fact, The authority by which judicial officer take cognizance of the said decides causes. The authority to hear and decide the legal controversy. Power to hear and determine the subject matter in controversy between the parties to a suit and to adjudicate or exercise any jurisdiction over them. The power to hear and determine the pronounced judgment on the issue before the court. The power or authority which is conferred upon court by legislature to hear and determine causes between the parties and to carry the judgment into effect. The power to determine. So whether the jurisdiction of the commission, my lord, State Meghalaya Regulatory Commission is, I have shown from the act, I have shown from the regulation, they have the power to decide the issue whether it can be recalled or not. Their case is, my lord, their case throughout has been, except this morning, that the commission has the jurisdiction.
As inherent.
Has the jurisdiction. Today morning they said that it has no inherent jurisdiction, my lord. Has the jurisdiction because they conceded, my lord, because this is the first point any lawyer will take, that the commission has no jurisdiction. But on that point they conceded. Today morning when I said that, look, if they have conceded to that extent that it has the jurisdiction, it at best it can be error in exercising the jurisdiction, error within the jurisdiction. If the order is bad, it will be at best the order has been passed wrongly, and for that you will go in appeal under Article 11. It's not a case of wholly without jurisdiction, my lord. A constitution bench of this court in Itiaravi Mathai versus Warke made a distinction between erroneous decision or limitation being an error of law which is within jurisdiction of the court and decision where court acts without jurisdiction in the following terms. The first point raised by Mr. Pakedi for the appellant is that decree under OS number 15 obtained by Anantha Iyer and his brother in the suit for the hypothecation bound executed by Ilya Raja in favor of so-and-so was a nullity because suit was barred by time. In assuming that the suit was barred by time, it is difficult to appreciate the contention of London Council that decree can be treated as nullity and ignored in subsequent litigation. If the suit was barred by time, yet the court decreed it, the court would be committing an illegality, therefore aggrieved party would be entitled to have decree set aside by preferring an appeal against it. But it is well settled that a court having jurisdiction over the subject matter of the suit and over the parties thereto bound to decide right may decide wrong, and that even.
But Mr. Tiwari said he has no quarrel with this judgment.
So then the principle, the principle which I am trying to highlight, my lord, is that the tribunal has the jurisdiction, because now this point has come in the morning only. Earlier, in absence of citation, there was no point.
I'll clarify myself. The purpose behind it.
The purpose is in rebuttal. If there is some purpose, then I have to admit that it is in the sense the term 23, my lord, has been used in section 16. So, and the principle of law on this issue is very clear, my lord, that it is not a case of exercise of power by the commission which can be termed as wholly without jurisdiction. Commission has exercised the power under the Electricity Act, rules and regulations framed by it, and the decision is also in accordance with law. There is no error apparent on the face of record, and therefore, in my submission, 3 requirements
are not met,
and the judgment are very clear that when it comes to public money, tax matters, your lordship will not exercise the jurisdiction in the first instance. Lordship will relegate the parties to alternative efficacious remedy, my lord. And this point, my lord, on this point, my lord, I will just place, your lordship just note down the paragraphs of the second judgment, my lord, that is at serial number 4, my lord, that Embassy Property Development Private State of Karnataka, my lord. That is 2013 SCC 308, paragraph 24, my lord. I will not take trouble your lordship with this paragraph, my lord, but the principles which have been led by, has been held by the Honorable Supreme Court in IFCO is squarely applicable to this case, my lord. Now, coming to the, my lord, last point, my lord, or the important that there is a suppression of the material fact, because suppression is writ large, my lord. Suppression is, my lord, that they were party to it, to BIA,
Yes.
And they concealed this fact. And they filed the second writ petition on almost similar cause of action.
Supplemental writ petition this file on your capacity.
This would, because in the prayer, my lord, the order is, both orders are under challenge. Recall order and tariff order, my lord. In BIA, my lord, recall order is only under challenge, my lord.
Yes.
So 28. Now, your lordship, on this issue, kindly see the case law in the compilation, my lord, which is at serial number 10. Serial number 10 and K. Jairam versus BDA, my lord, paragraph 7.
Yes.
$254, my lord.
Yes.
And the paragraph, your lordship may kindly see 7. At the bottom, my lord, of paragraph 7, my lord.
Yes. Illicit suit.
Yes, my lord, last placitum F. It is further contained, F and after 2 lines, it is further contained that the appellant has filed OS number before the civil court for BDA permanent. In the said suit, the very question involved the writ petition was raised. Said suit was dismissed by civil court and the said judgment was affirmed by appellate court. The appellant have not disclosed the dismissal of the first suit and appeal in the writ petition. Therefore, court has rightly dismissed the appeal even on the question of suppression of material fact. He prays for dismissal of the appeal, my lord. Now, kindly see 10. It is well settled that jurisdiction exercised by the High Court under Article 226 of the Constitution of India is extraordinary, equitable and discretionary. It is imperative that the petitioner approaching the writ court must come with the clean hands and put forward all facts before the court without concealing and suppressing anything. A litigant is bound to state all facts which are relevant to litigation. If he withholds some vital or relevant material in order to gain advantage over the other side, then he would be guilty of playing fraud with the court as well as with the opposite parties, which cannot be countenanced. Paragraph 11, my lord.
Yes.
In this court, in Prestige Light versus SBI, has held that a prerogative remedy is not available as a matter of course. In exercising extraordinary power, writ court would indeed bear in mind the conduct of party which is invoking such jurisdiction. If applicant does not disclose full facts or suppresses relevant material or otherwise guilty of misleading the court may dismiss the action without adjudicating the matter. It was held thus. 33. It is thus clear that though the appellant company had approached the High Court under 226 of the Constitution, it had not candidly stated all the facts to the court. High Court, in exercising the discretionary and extraordinary jurisdiction under 226 of the Constitution, over and above, a court of law is also court of equity. It is therefore of utmost necessity when party approaches a high court, he must place all the facts before the court without reservation. If there is a suppression of the material facts on the part of the applicant or twisted facts have been placed before the court, writ court may refuse to entertain the petition and dismiss it without entertaining into merit of the matter. In Udyami Ivam Khadi versus so-and-so state of UP, this court has reiterated that writ remedy is an equitable one and a person approaching the superior court must come with a pair of clean hands. Such person should not suppress any material fact but also should take recourse of legal proceedings over and above which amounts to abuse of process of law. In KD Sharma versus Sale, it was held thus: the jurisdiction of Supreme Court under Article 32 of the High Court under 2 is extraordinary, equitable and discretionary. Prerogative writs mentioned therein are issue for doing the substantial. It is therefore of utmost necessity that the petitioner approaching the writ court must come with the clean hand, put forward all the facts before the court without concealing or suppressing anything and seek an appropriate relief. If there is no...
One thing, in para 22 writ petition,
yes,
they mentioned that if you see para 22,
yes, my lord,
after challenging this 23.8 order,
yes, my lord, 22.
that does not conceal.
No, the
only thing they have not said is that
because Milord, the BIA is an independent entity and they are independent.
No, they have not said that.
Yeah, they have
have
so
not
they
said
are
that
they are
part and
they-
parcel
and
of BIA.
the
That's only
22
they've said that-
22 it is clearly inferred, my lord. 22 it is, see, I have come before your lordship by way of
Lordship, I read para 19 also.
I will read 19 also. Now 19, that prisoner through a high filed reply and participant in public hearing filed by 3
No,
utilities,
this is,
but they 19 before them.
That's
through
before the
commission, and but not before this 19.
Deal with it.
They will definitely deal with it. I am not saying they won't deal with it, because if they don't believe this matter will be dismissed on this point only, and this has to be dismissed on this point, because the question is, my lord, if you do not disclose that here in 19, you say I was participating there and I am not participating here. I am not participating through BIA. And it does this suppression not amount to abandonment also, my lord? This is abandonment, my lord. Kindly see Sarguja.
1987.
Yes, my lord.
One thing is that, see, the prayers is the same for setting
Prayer-
aside 28.
One prayer is common, my lord.
Exactly. The court notes that.
Yes, my lord. So therefore, can you agitate same thing again and again and not disclose this fact also, my lord? Kindly see Sarguja, my lord.
It's which,
In the volume 1 it is there, my lord. Page 222, my lord.
I think that you can't complete before lunch.
I'll finish it, my lord, so that
And Mr. Tiwari, how?
I'll take 1 hour at least, my lord. But wide range of issues have been covered, at least, my lord, because otherwise I have to answer.
What do you conclude within 1 hour?
Yes, in 1 hour I'll finish it.
Mr. Chanda, do you have any submissions to make, or is covered the entire submission?
I would pray, my lord, to fix this matter, my lord.
Then because otherwise this court wants to, want to keep it pending. I mean, we can. But then if you have.
Well, I'm appearing for the commission.
Oh yes, sorry,
I have
Mr.
about
Venkatesh. Yes.
Venkatesh is also here.
Yes.
15 minutes, but I think my learned AG has covered everything on my behalf, because I don't need to repeat anything, but I have just 15 minutes of submission.
Right,
Whatever your
okay.
options please is today.
Yes,
Today,
yes.
whenever.
No, we'll hear you first. Then Mr. Tiwari will make
Yeah.
his composite reply to all submissions advanced by the Advocate General and by your counsel for the commission.
Yes.
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 In
That
BIA
would be
commission,
better.
BIA has been made, BIA is part of the commission, my lord. Now kindly see serial number 18, my lord, and
Yes.
para 5, there, my lord. At page 225, my lord. In this case, we are called upon to consider the effect of withdrawal of writ petition filed under 226 of the Constitution of India without permission of High Court to file afresh. The provisions of Code of CPC are not in terms applicable to the writ petition, though the proceedings prescribed therein, as far as it can be made applicable, is followed by the High Court in disposing of writ petitions. Rule 1 of Order 23 of CP Code provides for withdrawal of suit and consequences of such withdrawal. Prior to the amendment of by Act of Rule of 1, provides for two kinds of withdrawal of a suit, namely absolute withdrawal and withdrawal with the permission of the court to institute a fresh suit on the same cause of action. In the first category, the withdrawal was governed by sub rule 1 thereto, as stood therein, which provides that at any time the institution of a suit plaintiff might, as against all or any of the defendant, withdraws his suit or abandon a part of his claim. Abandon a part of his claim. The second category was governed by sub rule 2, whereof provided that where the court was satisfied that suit must fail by reason of some formal defect, there was sufficient ground for allowing the plaintiff to institute a fresh suit for subject matter or of a suit or part of claim. It might, on such terms it thought fit, grant the plaintiff permission to withdraw from such suit or abandon a part of claim with liberty to institute a fresh suit in respect of the subject matter of suit or part of claim. Sub rule 3 of formal rule 1 of Order 23 of the court provides that where the plaintiff withdraws from the suit or abandons a part of the claim without permission referred under sub-rule 2, he would be liable to such costs as the court might award and would be precluded from issuing a fresh suit in respect of such matter or part of the claim. Since it was considered that use of word withdrawal in relation to both categories of withdrawal led to confusion, the rule was amended, my lord, and then thereafter at paragraph 6, my lord, it may be noted that sub-rule 1 of the formal rule, withdraw his suit, has been used in sub-rule is a new rule, my lord, and after dealing with all these aspects, my lord, what at the foot is, my lord, paragraph 9.
Yes.
At the point for consideration is whether a petition after withdrawal of a suit, withdrawing a writ petition filed by him in High Court on 226 without the permission to institute a fresh petition, can file a fresh petition in the High Court under the article. But on this point, the decision of Daryao is of no assistance, but we are of the view that principle underlying Rule 1 of Order 23 of the Court should be extended in the interest of administration of justice cases of withdrawal or writ, not on the ground of res judicata, but on the ground of public policy as explained above. It would discourage the litigant from indulging in bench hunting in tactics in the event there is no justification reason in such case to permit a petitioner to invoke extraordinary jurisdiction of High Court under 226 once again, my lord, while the withdrawal of suit, High Court without permission if file a fresh may not bar the remedies like in 32, my lord.
The point, Para 4 and 5 of Sarguja, that has not been
the point which I am trying to make is, my lord, that in BIA, through petitioner came before your lordship. In BIA, he challenged the order of recall, my lord, and there is no challenge to the order fixing tariff, my lord. So therefore, my lord, there is no challenge to, and that he could have amended now they are saying that he could have amended the writ petition, my lord. When the order came, he did not choose to do that. Petitioner did not choose to do that. Now, can he institute a second writ petition? Whether it is permitted, it would not, I put the question to myself, it would amount to abandonment, my lord. Once you abandon the claim, you cannot come again and file a second writ petition.
Yes.
That is the principle on which I am relying on Sarguja and these two judgments, my lord. And my lord, first and foremost, my lord, if lordship would not go into all these issues, if lordship will decide that there is an alternative efficacious remedy, the parties will have to be relegated back to the statutory remedy under appeal, my lord. Because then, once your lordship has taken a call that no, the writ is maintainable.
Examine, you see, under the three whatever factors which.
Yes,
because see, firstly, this court is bound by the judgments of this own High Court with regard to division bench.
Yes,
and other,
the Honorable Supreme Court
and all.
Yes,
so those are the things. So the court examine, like at this juncture, whether this order passed by the commission. It is such an extent that militates against, those principles that have been laid down.
Yes,
and the orders of this court.
Yes,
right. If this court finds that yes, the order is without jurisdiction on excess.
Wholly without jurisdiction.
Wholly without jurisdiction, yes.
And without jurisdiction issue, error of jurisdiction.
Yes. Now, error of jurisdiction is different.
Yes, my
lord. Now, in absence of, it's non-est.
Yes, my lord.
Holding
yes,
then
then your lordship would go into the other issues, because all these issues will be open for them to take up in appeal, my lord. That whole exercise, the entire exercise, your lordship may not be required to go to see the various powers, etc.
Yes.
The scope and remit of the entire exercise will be, in my humble submission,
yes,
would be limited to examine whether they cross the threshold of alternative remedy or not, my lord. If they cross the remedy, then your lordship may go into the.
Yes, Mr. Venkatesh,
yeah,
we'll hear you at 2:15.
Yes.
And other matters, other hearing matters.
13.
Lordship, item number 13. Subject to Lordship convenient, Lordship, any day.
I think it will be possible today. Yes, 13 is?
13, Lordship, this week.
Who's there? Sorry, who are the councils?
Lordship,
Ma'am Yangi. Ma'am Yangi. Yes. You're with MST Yangi? 13 is.
Item 13. Item 10 by John.
Rikrak Moment.
Rikrak Moment.
You're for the petitioner?
I'm for the petitioner, Lordship.
We'll have it after 2 weeks, yes.
After.
And
Obliged.
then,
Obliged,
18?
My lord,
18.
item number 18, my lord. Lordship, it may be kindly fixed tomorrow, Lordship. Its matter is urgent.
That's what they're objecting vehemently, Mr. Jindal.
I'm here, my lord.
Yes, you've been playing hide and seek in the earlier days.
No, I'm always around, my lord. Tomorrow, slight problem. Day after. Day after.
No, not day after. Day after is court traveling. We'll have it on Monday.
Tuesday, if I can pray, my lord.
Tuesday.
Tuesday. Coming Tuesday.
Yes, Tuesday.
Obliged. Highly obliged.
Please, Lordship. Item
You
number
file it,
24, I have, Lordship, I have filed it, Lordship.
Received copy?
Yes, I'm.
Lordship, we have
they
received a
received.
copy, Lordship.
Then list the matter after 2 weeks, yes. See, because we
No
can't
problem,
take the
Lordship.
submission as face value that I will
Yes.
file and adjourn the matter.
Actually, did it difficult?
Much obliged, Lordship.
Lordship.
215. इसका क्या इसका ओके
Whom you serve copy?
Yes, Mr.
Made to your only one citation, my lord, one judgment, short judgment on the issue of non-maintainability of the second repetition, my lord. Nawab Hussein's judgment is there of 1977. Because I will only take 2 minutes, my lord.
Yes.
Lordship, kindly see page paragraph 3. Facts of the case are that, my lord, one writ petition was filed, which was dismissed, and then second suit was filed, my lord. Then the High Court said that it is not barred. The matter travelled to Supreme Court. Paragraph 3, my lord. Principle of estoppel of per rem judicatum is a rule of evidence, as has been seen in Barrington versus Blackburn Borough Council. It may be said that broader rule of evidence which prohibits reassertion of a cause of action. This doctrine is based on two theories: the finality and conclusiveness of judicial decisions for final termination of dispute in general interest of community as a matter of public policy, and the interest of the individual that he should be protected from multiplication of litigation. It is therefore served not only a public but also a private purpose by obstructing the reopening of matters which have been once adjudicated upon. It is thus not permissible to obtain a second judgment for the same civil relief on the same cause of action, for otherwise the spirit of conciseness may give rise to conflicting judgment of equal authority, lead to multiplicity of actions, and bringing administration of justice into disrepute. It is the cause of action which gives rise to an action, and that is why it is necessary for courts to recognize that a cause of action which results in judgment must lose its identity and vitality and merge in the judgment when pronounced. It cannot therefore survive the judgment and give rise to another cause of action on the same fact. Therefore, that is what known as general principle of res judicata. But as it may be that the same set of facts may give rise to two or more cause of action. If such a case, a person is allowed to choose and sue upon one cause of action at one time and reserve the other for subsequent litigation, that would aggravate the burden of litigation. Courts have therefore treated such a course of action as an abuse of process, and Somerville so and so. So, my lord, I rely on this judgment for two propositions, my lord. Your lordships, we were before your lordship, and your lordship gave me liberty to go back. Yes. BIA was also before your lordship in that, and that liberty was given, and it was not at all agitated and said that, or that liberty granted by you, by your lordship, could not have been granted, and it is granted erroneously, or I was not in. That order has attained finality, my lord. And once the party has been remanded by, parties have been given the opportunity to agitate the issue by the order of this honorable court. Yes. Objection, if any, they could have raised at that point of time. They can't raise this objection after the order has been passed, my lord. That is one, my lord. Second, my lord, is with regard to filing of the second writ petition by individual member of BIA, my lord.
Yes.
Cause of action, so far as the first BIA petition is concerned, and cause of action in the individual member is concerned, my lord, both overlap. And therefore, this says that it is not in paragraph 4. It has been said that it is abuse of process of law. That is all I have to submit, my lord.
Thank you.
I am grateful.
Yes, Mr. Venkatesh.
Yes. I'm grateful to my esteemed senior mirrors who has already shown your lordships
everything. Yes. Yes.
Yes. So I'm not going to repeat anything which has been argued by my esteemed senior mirrors. If I've understood correctly, in response to the writ petition filed by individual consumers as well as the court association, there are three broad grounds, mirrors, which have been taken by the respondent DISCOM. One is of the alternative remedy. What are the contours of 111.1 and whether these issues could be raised in an appeal. Second, the law in relation to quorum of principle which has been settled as far back as 1959, that those who hear must decide in Gullapalli, Nageshwar Rao, my lords, famous case where the learned advocate general had to resign. In fact, I believe the chief minister also had to resign because of that very decision. All that has been shown to your lordships. And my lords, then there are arguments made by my learned advocate general on the inter-party issues for which, my lords, the commission is not going to make any submissions upon. That's, my lord, for your lordships to consider between the consumers and the DISCOM, whether on the grounds of res judicata, on the grounds of multiple writ petitions being filed. We're not going to touch upon that on behalf of the commission. Now, my lords, only to assist your lordships on the principal point that whether the commission has exercised its jurisdiction appropriately in issuing a recall order by relying upon the tribunal judgment, and what is the interplay of section 92 and 93, my lords, is on where I'm going to focus my submissions upon. Because according to me, that is the fulcrum of the dispute. Once the lordships are satisfied, presuming the lordships are getting into this question after the alternative remedy consideration, if your lordships are satisfied that the commission was supposed to, duty bound to, and statutorily bound to reconsider its case, then perhaps the other arguments, my lords, may not be required to be gone into. Now, my lords, to understand that, and I'll come, my lords, I believe the petitioners, my lords, have laid emphasis quite heavily so on the judgment of the tribunal passed on 2nd December 2013 in OP 1 of 2011. That seems to be, my lords, the bulk of the reliance is placed on paragraphs 7 onwards to say that the commission has that power to go ahead and decide matters if there is a vacancy in the court, and for that they rely upon section 93. That seems to be the argument, my lords. I will, my lords, in my respectful submission, each order or each judgment is contextual, and the context in which the 2nd December 2013 order was passed is my lords, perhaps to throw light on whether this is if at all there is an application of this order in the facts of the present case. Now, before I make that point, would my lords be kind enough to have the Electricity Act for 1 minute? I'll just place a few sections so my lords' consideration, then I'll straight away come to the judge. Minutes. Your lordships, if your lordships have the Bare Act, my lords, the part 10 is the Regulatory Commission's chapter, which begins from section 76. My lord would have 76. That is on the constitution of Central Commissioners. We're not concerned with this, but if my lord would kindly turn over a few pages and kindly come to section 82. 82, my lords, deals with constitution of the State Commission. And may I just place this section? Every state government shall, within 6 months from the appointed date by notification, constitute for the purposes of this Act a commission for the state to be known as the name of the state, Electricity Regulatory Commission. Now, kindly, my lords, have said, may I have the provided that the State Electricity Regulatory Commission, established by the state governments under section 17 of the Electricity Regulatory Commissions Act and the enactment specified in the schedule, and functioning of such immediately before the appointed date, shall be the State Commission for the purpose of this Act, and the chairperson, members, secretary, and officers, and other employees thereof shall continue to hold office on the same terms and conditions of which they were appointed under those Acts, provided further that the chairman and other members of the State Commission appointed before the commencement of this Act under the Electricity Regulatory Commissions Act or under the enactment specified in the schedule may, on recommendation of the selection committee constituted under subsection 1 of section 85, be allowed to opt for the terms and conditions under this Act by concerned state government. Now, let's clause 2. The State Commission shall be a body corporate by the name aforesaid, having perpetual succession and a common seat, with the power to acquire, hold, and dispose of property, both movable and immovable, and to contract shall be any said name, suit, or be sued. Head office of the State Commission shall be in such case as the State Government may notify specified. The State Commission shall consist of more than 3 members, including the chairperson. The chairperson, I need note notes 5. The chairperson and members of the State Commission shall be appointed by the state government on the recommendation of a selection committee referred to in section 85. Now, the reason why I placed section 82 to begin my submission is because what is the constitution of the State Commission? Namely, who is State Commission, where is it situated, and how its members are appointed. are all subject matter of section 82. And this becomes clear if your lordships may straight away now come to section 93, which is not where the bulk of the argument seems to be. No act or proceedings of the appropriate commission shall be questioned or shall be invalidated merely on the ground of existence of vacancy. Now, this is not a case of existence of vacancy or defect in the constitution of the appropriate commission. Kindly mark that phrase.
Yes.
And I will show one judgment, my lords, which deal with a similar provision under the Waqf Act, but this is what it is. So, my lords, my first submission is 93 as a provision really inures to those cases, A, where the entire commission is not appointed. For the matter, there are 3 members required, effectively one from law, one from technical, and one from finance. Presume in a given case, where supposedly member finance's position is remaining vacant, the commission is constituted to hear a particular tariff petition. That constitution of commission could not be brought under question by the help of section 93 because the commission is validly constituted. There may be an infraction in the constitution, but that infraction will not invalidate the judgment.
Right.
I hope I'm able to explain that point.
Yes.
So therefore, 93, my lords, is a specific enabling provision available not only under the Electricity Act, available in plethora of other statutes which effectively protect. Because as your lordships are aware, nobody better than your lordships can perhaps appreciate this point. These appointments take time, and therefore, for large number of months or years altogether, the entire quorum is not available. And if we were to wait for the entire quorum to be created or to be established,
then no work can be done.
Commission cannot pass tariff orders or decide matters. Therefore, 93 inures to this, and this gets further fortified. If your lordships may kindly look at section 84 and 85.
Yes.
I'm just giving what could be potentially a defect in constitution. 84 my lord prescribes the chairperson and the members of the state commission shall be persons of ability, integrity, and standing who have adequate knowledge of and have been shown capacity in dealing with problems relating to engineering, finance, commerce, economics, law, or management. Notwithstanding anything contained in subsection 1, the state government may appoint any person as the chairperson from amongst persons who is or has been a judge of a high court, provided that no appointment under this subsection shall be made except after consultation with the Chief Justice of that high court. The chairperson or any other member of the state commission shall not hold any other office. 4th, the chairperson shall be the chief executive of the state commission. Now, another kind of defect potentially could be that the state government appoints an individual to be the chairperson of a tribunal or of the commission, but he has not held a position or a legal member, but he has not held a position of an honorable high court judge. In that case, there is the litigation pending against his appointment before the honorable high court. Let's presume another case. Now,
that's a de facto doctrine. That's a de facto doctrine. There is no quarrel with the proposition. We call it de facto doctrine.
I think I am not, my disability is I could not,
catch what.
I just refer to de facto doctrine. There is no dispute with the proposition.
Yes.
De facto doctrine it is called.
I'm grateful if you are agreeing with me on that. Therefore, my lords, while that office is where the member continues to discharge his obligation in the office, merely because his appointment is brought into question and perhaps is sustained in a writ petition, that will not take away the actions taken by that member by the advent of section 93. That's the scope of 93. That's my first point. Now to buttress this very argument that what is 93, I should not lay my hands on a judgment of the Honorable Supreme Court dealing with 93 in specific, but I could refer to a judgment of the Maharashtra High Court, I think, and my colleague will hand over that individual judgment. It's Kambil Jivaji versus State of Maharashtra. If that judgment could be handed over. It's I think Bombay High Court.
Yes.
And if your lordships may kindly look at this is under the Waqf Act, and if your lordships may kindly see the court had to deal with a similar procedure. Justice Tamadikari Millards, his judgment, and your Lordships may kindly have this Millards paragraph 20. In fact, Millards, paragraph 20 Millards is the argument of the board that they can proceed to hear and hold hearing despite not having constitution. Kindly see that.
Yes.
The state government, however, permits the Waqf board to proceed further with consideration of petitioner's matter responded to board, as also its members respondent number 3 to 6 also intends to decide the same. They rely upon section 23 of the Waqf Act to urge that no defect in constitution or existence of vacancy in Waqf board can invalidate its proceedings. She shows a learned senior counsel who during the argument submitted papers containing similar provisions from other enactments with the stand that this arrangement in the statute is a standard practice. However, the question before is not about invalidation of proceedings already concluded, but pertains to pending ones. Section 22 reads as under: vacancies, etc., not to invalidate proceedings of the board. No act of proceeding of the board shall invalidate reason only of the existence of any vacancy amongst its members or any defect in the constitution thereof. Same section, very similarly worded. Now, kindly see the paragraph after that. It is obvious that a such section is not an enabling provision, but a saving one. It cannot and does not mean that the Waqf board with a definitive defective composition beside and Parliament has given its license to do so. After 4th of September 2008, notification there were 9 members of Waqf board, and at present its strength is only 4. Precedent cited by learned senior counsel in regard does not show how any such leave to decide despite knowledge or defect. Honorable Apex Court and Gulzari Lal Agarwal versus Accountants Officers found that the National Commission functioning under the Consumer Protection Act set aside concurrent orders of the District Forum and State Commission on the ground. Jurisdiction as the President of the Commission was not a party to a decision, as it passes only 2 members. In paragraph 11, section 29 of the Act, worded like section 22 of the Waqf Act, is noticed, and then in paragraph 17, Honorable Apex Court has gathered intention of legislature not to render the State Commission non-functional in the absence of the President, and it found that in his absence, senior members is to function as President. For facts in Akhil Bharat Goseva Sangh versus State of AP and others revealed that the Chairman and Member Secretary of the AP Pollution Control Board did not possess necessary qualification. And Honorable Apex Court noticed the High Court did not address specific breach of statute requirements in this respect. It noticed that some of its members were scientific experts. In this background, the Honorable Apex Court considers Section 11 of the Water Prevention and Control Act, which provides that no act of proceedings of a board or any committee thereof shall be called into question on the ground of merely of existence of any vacancy or any defect in constitution thereof by the board or such committee as the case may be. Therefore, applying Section 11 of the Act, which clearly provides that no act of proceeding of ATPCP or any other committee thereof shall be called in question, Honorable Apex Court concluded that even if there was some defect in the composition of ATPCP, that would not invalidate the consent order issued by it. Observation learned single judge Honorable Delhi High Court and so and so Trilocham Singh Rana versus Jogendra Singh are to be cited to explain interpretation of Section 20 Delhi Sikh Gurdwara Act 1917. So therefore, multiple acts were noticed by the Honorable Court only to say that this is a saving provision to help you from tiding over any vacancy or the defect in the constitution of the commission. It does not, grant any plenary power to the commission to override, the law which is being settled since 1958.
My Lord, my friend, I agree with him. I accept it.
11 being submissions.
I accept the submission.
Yes.
I agree with the submission.
Yes.
Now, yes. Lord, in that context, I am grateful for my esteemed senior lords for validating my submission. In that context, my lords may kindly have the judgment of OP 1 of 2011. This has been referred to, my lords, through several compilations. In fact, I think one compilation has been handed over by our side as well, lords, and we are extremely apologetic of not coordinating and not ensuring that we save some trees. But if the lords may have that compilation, the last judgment of this is at page 317. The short order minutes.
Yes.
And you have to kindly see minutes. Paragraph 1 itself refers to minutes. In pursuance of the earlier direction issued on 31st of May 13, the Forum of Regulators have filed the latest status report dated 16 September 2013. We have perused this status report. We have also requested the Learned Amicus Curiae Council to go through the report and give their suggestions with regard to the further directions to be issued to Commission and orders. Accordingly, they filed their suggestions. On perusal of status reports submitted by FOR, it is clearly that by and large, majority of the regulatory commissions have implemented are in process of implementing directions regarding the multi-year tariff regime in their respective states. But in regard to non-implementation of various directions issued by this tribunal, we are constrained to give further directions to the commissions as well as persons concerned on the basis of suggestions submitted by the Amicus Curiae Council. Now kindly see paragraph A. What was the context of paragraph 9? Uttar Pradesh State Commission, in its response, have expressed their inability in framing of the multi-year tariff regulations and processing of through petitions. This further stated that the same would be completed only upon the constitution of the full commission. Yes. According to them, the vacancy of the chairman and member in the state commission has not been filled up yet. However, as of date, it is informed that this tribunal that both the vacant positions of chairman and member have been filled up, and the new chairman and member have already taken charge in the state commission. Therefore, the Uttar Pradesh Commission is directed to frame MIT regulations without further delay, as we had directed earlier, and put the same in place by the end of the current financial year. I'll just dilate here for 1 second. There was a judgment sent earlier issued by the tribunal in the very same proceeding, in which the sum and substance of that proceeding is that Ministry of Power, which is the nodal ministry under the aegis of the Government of India, had issued a letter to this appellate body to say that state commissions are not passing tariff orders in time. They are not passing tariff orders. There is under recovery by DISCOM, and that they are not framing their regulations. As a consequence thereof, a judgment was delivered in 2011. I'll place it in my note. In that judgment, the tribunal had issued a direction, a peremptory direction to all state commissions that please frame your regulations dealing with tariff and please issue a tariff order each financial year before 31st March of the financial before 1st of April of the financial year commencement. That was a broad set of directions. When the matter was being disposed of, a report was called from all state commissions to show whether they complied with this law. Now, this order in question, which has been relied upon by the petitioners, came to be issued in the context of the report submitted by each commission to the tribunal.
We get it, yes.
Now, and the argument some commissions took that we can't frame regulations, because we can't pass tariff orders because the
lack of members
is not good.
Yes.
Yes. Now, in that context, paragraph 9 and 10 were issued by the tribunal. Kindly look at paragraph 9. Paragraph 8, in fact.
In its context.
Yes. In this context, it is to be pointed out that this tribunal has already rendered judgment while interpreting section 93 that any decision taken by the commission should not be invalidated by mere fact that there is some vacancy either of the commissioner or member. In view of the above decision, we are to direct all commissions to conduct the proceeding irrespective of the quorum, since the proceedings before the commission could be conducted even by a single member.
Yes.
Of course, section 82(4) of the Act provides that state commission shall consider. However, section 93 of the Act provides that no act of proceeding with the appropriate commission shall be questioned or shall be invalidated and merely on the ground of any vacancy or defect in the constitution of the commission. In our view, since the quorum depends on the number of members of the office, even a single member of the commission, including the chairperson of such a commission, can conduct the proceedings of the appropriate commission. Now, but therefore, one has to see these paragraphs 8, 9, 10, and 11
in the context of what it was generated. Okay.
Yes. The context was they were not passing tariff orders and they were not issuing regulations. So the tribunal said, look, 93 protects you. Do your job and frame regulations and pass tariff orders. That's the law.
So comes our argument, Mr. Tiwari, regarding off and before. So you mean with off, 93 is with off. And before is the different, different perspective.
Yes. This has not been answered till now. I will elaborate that. This has not been answered till now. Nobody could answer it.
Yes, okay.
If my esteemed senior would permit me, I'm coming to that. One step better.
Yes.
I am now first dealing, my endeavor, to wait, first 10 minutes was to show to your lordships that this judgment is not a judgment dealing with the question which was the subject matter of Millard's deliberation before your lordships in the first round or in the second round. That's the first submission. I'll rest my case here. Now, Millards, on the second point, which has been alluded to, Millards, my esteemed senior, to say that there seems, the argument, if I've understood correctly, is that there is no inherent power available with the commission, And since the commission lacks any inherent power, it could not, even if there is invalidation of proceeding or there is a situation where quorum is not created appropriately and which leads to a defective proceedings, the commission could not have recalled the order. That's really the sum and substance of the second part of the submission. In that, your lordships may first look at section 92(1), then kindly come to section 181. Please have your section 92(1) for a minute. Proceedings of the appropriate commission. Kindly mark this. Now I'm dealing with of and for articles.
Yes.
The appropriate commission shall, at the head office or any other place, at such time as chairperson may direct, and shall observe such rules of procedure in regard to the transaction of business at its meeting, including the quorum at its meeting as it may specify. Now, my lords, the Parliament in its wisdom deemed it appropriate that each commission shall specify its own conduct of business regulations or rules to ensure how the commission will function. Now, in that background, please have a look at section 181 ZK. And that's the place in that section for a minute and go to ZK straight away.
Yes.
Yes.
The term condition.
181 says, Lords, yes, the state commission may by notification make regulations consistent with the act and the rules generally to carry out provisions of this act. Clause 2, in particular and without prejudice to the generality of the power contained in subsection 1, such regulations may provide for all or any of the following matters, namely. Now we have ZK, which your lordships will find, yes, at ZL, sorry, which is at page 89 of the Bare Act. Rules of procedure for transaction of business under subsection 1 of section 92. So, my lords, the straight answer to my esteemed seniors' contention is that 93 is a protection of the quorum from invalidation on account of a defect. 92(1) read with section 181 ZL is the enabling power given to a state commission by the Parliament to frame its own business transaction rules. And as has been shown to your lordships by the esteemed Advocate General Millard in his compilation, the very first annexure, the conduct of business rules and regulations have been provided for. That very conduct of business regulations does two things, Millard. A, it prescribes that those who hear the matter must sign the order. It's already prescribed in that. That's point number 1. Point number 2, Millard, it also prescribes that the commission with itself keeps an inherent power to rectify an error of this nature if it occurs while transacting business. Both powers are vested with commission itself has prescribed for itself. Commission has prescribed for itself. And this is, Millard, in exercise of power given not by another delegate legislation, by the Parliament itself, under section 92, subsection 1. Now, Millard, the judgments that have been relied upon to show that the commission does not have inherent power, presumably, because I have not seen that judgment and I will put it in my note because I don't think as a respondent you will like to sir rejoin. But those cases would not be covered, would not be applicable here, because here, Millard, section 181, subclause 1, very categorically says that I have the subordinate legislation making power as long as I am doing it in furtherance to the act and inconsistent with the act. That's the sum and substance of my submission. Therefore, you cannot, and this issue has been dealt by the Honorable Supreme Court. I'll come to that in a minute. Therefore, Millard, the straight answer to section 92 versus 93 is this. Under 92(1), there is a regulation frame. The regulation has a requirement of quorum to be adhered to, very consistent with the law laid down by the Honorable Supreme Court in Gullapalli matter of Andhra Pradesh of 1958. That very regulation also has the power vested with the commission to recall its order in the nature of inherent power, which has been vested, which has not been questioned or been challenged by any of the petitions, at least in these round of petitions. That's the state point. Now, Millard, dealing with the argument, Millard, that has been made, that could a statutory body which has by regulation made conferred itself an inherent power, could it recall its order in a given case? That judgment, that answer, Millard, that judgment is already, Millard, I think it's in my compilation. If your lordships may kindly have Millard's the Honorable Justice Chandrachud's judgment of 2024, which is, my lords, it begins, my lords, at
Page?
page 125. Greater Noida, 124. Greater Noida versus Prabjeet
Okay.
Singh Soni. This was read by my esteemed senior from the petition.
Yes,
but
yes,
I want
yes.
to place few paragraphs, my lords. Kindly see, my lords. Kindly have page 149.
Yes.
Paragraph 39. The issues of rate.
Yeah, that is.
Upon consideration of the rightful submissions, following issues that have arisen, whether in exercise of power in subsection 5, section 60, adjudicating authority institution can recall an order and approval passed under subsection 1 of section 31 of IBC, whether the application of recall orders are barred by time. Now, Millers, here kindly see paragraph 40, the recall issue is discussed, and your lordships may kindly note Millers paragraph 42, identical provision to our regulations. Rule 11 of the National Company Law Tribunal Rule 2016, framed under section 416 of the Companies Act, which is paramateria with section 115 of the Civil Procedure Code, preserves the inherent power of the tribunal in the following terms. Now, Millers, may kindly note this. Nothing in these rules shall be deemed to limit or otherwise affect the inherent power of the tribunal to make such orders as may be necessary for meeting the ends of justice or to prevent abuse of process of the tribunal. So that's the power noticed by the court, Millers. Then kindly have, Millers, they cite, Millers, Manohar Lal Chopra at 43, Gridley's Bank at 44, and then Millers 45.
And this has been placed by the Advocate General.
Yes, so, but ultimately, the conclusion is at paragraph 48 to say that once a rule of this nature is framed, which is akin to section 151 Civil Procedure Code, kind of just 48, also just mark this.
Yes.
48 very categorically then says that the law which emerges from the above decisions above is a tribunal or a court is invested with such ancillary or incidental powers as may be necessary to discharge its functions effectively for the purpose of doing justice between the parties, and in the absence of such prohibition, in an appropriate case, it, now kindly mark this, in the absence of a statutory prohibition. So the inhibition is inherent. Prohibition has to be statutorily prescribed. In an appropriate case, it can recall its order and exercise of such ancillary or incidental powers. That's, Millers, the long and short, Millers, of the submission on the recall. Therefore, Millers, in my respectful and humble submission, Millers, and I will just, Millers, place that quickly so that I don't want to repeat anything which has been argued, Millers. Millers, the 5th of June 24 order and 6th of June 24 orders as passed by the Commission were signed by, Millers, an individual member as opposed to the quorum which had carried out the public hearing. Therefore, Millers, this particular post ran foul of regulation 18 subclause 3 of the conduct of business regulation. I'll put it in a 2-page note, Millers, so it's there for your lordship consideration. And I'll refer it to, Millers, the Learned Advocate General's compilation, which says that all orders of the Commission shall be signed and dated by the chairperson and members hearing the matter and shall not be altered except to correct the apparent error. And this is consistent with Millers Vishwanathan. Therefore, Millers, that's the infraction, that was a defect which went to the root of the matter. Pursuant to a writ petition filed before this Honorable Court, Millers, we undertake to reconsider the whole issue because to clarify this defect. And then, Millers, in exercise of my inherent power under Regulation 26 of the Conduct of Business Regulations, read with Regulation 111 of the MIT Regulations, we recall the order, relying upon, Millers, the Honorable Supreme Court Judgment Greater Noida, and then, Millers, the tariff order has been passed. Now, Millers, as the Learned Advocate General, Millers, has adverted to in his submissions, and I just want to place that fact before your lordships because I'm only appearing in one matter, which is item number 10, which is the BIA, Millers.
Which is the mother matter, yes.
This is the mother matter. But the mother matter, Millers, has, Millers, according to me, left out a very crucial aspect. The mother matter is only against the recall order, where no rights are being affected. Well, how do we mount the case of Article 226? We have to argue that certain vested rights have been taken away in exercise by Millers in violation of Article 14, 19, 20, whatever be the case. Now, in this order, there is no rights being taken away. All that the Commission said was this was a defect. We wish to cure it. We will hear everybody and pass a tariff order. We heard everybody. We passed a tariff order. But, Millers, the next logical step which was required to be taken by them presumably by a fresh writ petition or by amendment, which has been adverted to by the esteemed my lords Advocate General, that has not been taken. So, my lords, your lordships are effectively asked to decide a question where admittedly there is no violation of that, where there is no violation of fundamental right, because no rights have been violated yet in that order. At best, my lords, they may, I don't know whether they do or not, they may have some grievance against the tariff order, for which, my lords, there are remedies which have been adverted to by the esteemed my lords Advocate General. Therefore, I would not, my lords, repeat that. Therefore, my lords, if the BIA falls, then according to my lords, all of this is, my lords, according to me, all these issues can be raised, my lords, and I support the esteemed my lords Advocate General in his submission that this is now the law is very clear, my lords, after Justice Gawai's judgment in the Rajasthan matter, and in fact, the lordship's own order, which is shown to my lords, which has been placed for consideration. I don't think, my lords, it lies on any side to maintain a writ petition when the remedy is available, my lords, and I've not still heard how that remedy is inefficacious for them. That I've not heard so far, my lords. And last point is this, my lords, this because Mr. Paul had made this submission, I don't know whether, my lords, the petitioner also wishes to make this submission here. They, my lords, as the lordships are aware, my lords, Whirlpool makes an exception to an alternative application remedy, which is inherent lack of jurisdiction. If it is a case of inherent lack of jurisdiction, then a writ petition would lie in addition to a statutory remedy which may be available to a party. Now, my lords, I don't think, my lords, anybody can argue on either side that the State Commission lacks inherent jurisdiction to pass a tariff order, because nobody other than the State Commission can fix a tariff under this parliamentary enactment. Therefore, my lords, if it's a wrongful exercise of jurisdiction, or my lords, if there is an infraction in exercise of jurisdiction, that's an appealable issue. That's a revisional or appealable issue. For that, my lords, my lords, note that in my compilation, I've referred to it, my lords. In my compilation, I have referred to, my lords, the judgment on Rusli Wade, which your lordships will find at page 165, and the relevant extract is at page 1. The relevant paragraph is paragraph 37 at page 196. I just placed this. There is the difference between existence of jurisdiction and exercise of jurisdiction. In case jurisdiction is exercised with material illegality or illegality, it would be constituted as jurisdictional error. However, if a court has jurisdiction to entertain a suit, but in exercise of jurisdiction a mistake has been committed, though it would be a jurisdictional error, but not lack of it. It may be a jurisdictional error open for interference in appellate or revisional jurisdiction. So it's very clear. Surely, my lords, nobody can argue that the State Commission itself lacks jurisdiction to fix the tariff. I don't think that can be a case mounted against us. Even if it's a wrongful exercise of regulation 18 or 11 or, my lords, the inviting regulations, all of it is subject matter of challenge under appeal, where a full breath is given them to argue on facts and law both. It can't be said that this is the case of, my lords, inherent lack of jurisdiction. So, my lords, have the judgment with Rusli Wade? 165?
Yes.
And then 37 onwards is the discussion.
Yes.
37, my lords, put the entire argument in a very crisp manner, so I only relied upon that. So, my lord, I will just, in support of, my lord, what has been argued by the Learned Advocate General, my lord, I will put a 2-page note, my lord, for my lord's consideration. Whichever, my lord, way. I'm so grateful, my lord, for a very patient hearing.
Mr. Tiwari, I think you have to reply tomorrow. You won't have enough time.
My lord, again I go, again I come in the morning, and my lord, I thought,
part of the advocate's life.
my lord, at least some respite, my lord. If not for any other reason, at least for these grey hairs. I am not as young as many of us over here.
No, I don't think you're as old also.
My lord, 64 is not very young either. 64 is not very young either. My lord, either I continue till 4:15 or 4:30.
The problem is that, you see, we have this NLU meeting where the Chief Justice Chancellor...
Otherwise, I thought I will take some indulgence of your lordship. I will continue till 4:30.
I can, if I had no
in 1.5 hours, I would have finished everything.
I can hear you till 5 o'clock also.
So that's so nice of your lordship.
But if Mr.
Lord, could it be day after in that case?
I'm instructed that he'll be, my lord, because of his morning period, my lord.
1 month.
My lord, till 20th, my lord, he'll be off.
The 20th of March.
21st, he'll be here, my lord.
But in my case, day after, I'll come and finish it off.
Not Wednesday.
Devashish. Oh. He's afraid because his case is before a court which never gives adjournment. And his petition will be dismissed. So he's worried.
But Mr. Tawari, I remember from Justice U.L. Bhatt, he could never get adjournment from his court. But that time we were juniors,
but
and,
since my
and
lord,
he went and
yes,
mentioned, and took Justice U.L. through the entire case, and he got the adjournment. I remember, so it was a lesson.
My Lord Justice Bhatt, I remember, the then Chief Justice.
Yes. 93.
Yes, that 93.
And how, because we were never mentioned before his court number 1 got he. Because you won't get adjournment, but then he was brave enough. He went and mentioned, but how he mentioned it, adjournment.
I got the biggest compliment from my Lord Justice AP Singh that his style of mentioning is such that I can't say no. So I have to give adjournment. Milord, then could it be? Milord,
he succumbed to that also.
So Milord, then Milord, kindly consider then prayer from 2 sides. So far as I am concerned, I have no difficulty even day after I can come. Certainly not tomorrow, but since Milord, genuine problem and I require some assistance, let it be on Monday, Milord, we'll finish it up.
Monday is 3rd. No, sir, 3rd.
We'll finish it up, the entire thing.
Milord, I will Monday I'll join virtually, Milord.
No problem. I think we've heard you substantially.
Yes. My friend has presented everything. Everything. He has left nothing. And whatever little was left, the hammer came from the other side, the commission. So I am being hit from 2 sides.
Interim order.
He is worried for the interim order because
Milord, I have one issue, Milord.
Just morning, there is something.
Because Milord has seen the merits of the case, Milord, and they have to pay the tariff as per
want to generate a judgment.
My Lord has not seen the merit. My Lord will deliver the judgment.
They have to give the tariff as per
We are
tariff
paying
order.
the
They have
tariff.
to pay.
Tariff.
And we are only
We'll
asking.
give you a concession. If they don't succeed, that means the installments as due, instead of 9 installments, will be limited to 4 installments maybe.
Ultimately, because they are beneficiary of the stay, Milord.
Milord, I have not given a reply. My London friend should not be so confident that my case is gone. I have not given a reply. I have.
No case is gone till the time it is
That's
fully
it.
heard and
That's
judged.
it.
And
That's
that's
it.
I'm now old enough to understand that law
That's
is
it.
law. But ultimately,
Monday. Matters stand through to Monday.
Sure.
Interim orders continue little then.
इसको मिसप्लेस हो जाएगा
नहीं आपका पूरा अलग करना